on this portfolio committee meeting of the PC on agriculture, land reform and rural development. Good morning, goeiemorgen, molweni, dumelang bagaetso. We, on our agenda today, will be having a briefing by the Minister on the accountability of Ingonyama Trust Board, as well as Ingonyama Trust, and also the role and responsibility of the Special Master and the department in processing of applications for labor tenants. We do, honorable members, also have our report, which was circulated on the oversight we did in Kirkwood, which will need to be considered and adopted if time allows. But also there'll be our last set of minutes, if there is any, to be adopted, as this, honorable members, is our last meeting of the year. We hope that we will have a very fruitful engagement on the deliberations of today. Those that have been following up the World Cup with interest, it has been highly entertaining, with our African countries flying the African flag and bringing joy to many of us in the continent. We've watched Tunisia, Ghana, Cameroon, and Senegal with real enthusiasm as they have been shining on a global platform in Qatar. We want to congratulate our African brothers and their endeavor to making it into the second round of 16, and hopefully to see them go even to the finals and aspiring to winning the cup. But also on the home front, we have been facing the challenges and the problems centered in and around the pit bull attacks. And there's been various inputs from all sectors on this, and having a call for a better management of these pit bulls by the owners, but also a reflection in terms of the SPCA, as well as the legislators, in how we should be looking best to bringing up legislation that will ensure that the owners of these animals are able to be held to book. So we issued a statement yesterday as a reflection of what our position and thoughts are as a committee. And we hope that the ministry will look into that and also see as to what role they can be able to facilitate and play in ensuring that we are able to find an amicable solution in regards to the protection of these animals, but most importantly, the protection of lives, because it's totally unacceptable to see our citizenry being mauled by these moleholes. And this has invoked a call for them to being put down and banished. So we do hope that this matter will be attended to and resolved. But as the Honorable Minister was remarking that we are seeing the wonderful rains and hoping that they are spread right throughout our landscape of our country, and ensure that we are able to see our sector utilizing these rains and the waters to ensure that they are household gardens, their fields, and small-scale farmers get to work in securing food security, which is much needed. But let me, honorable members, get into why the committee has requested this meeting with the Honorable Minister Umamutogoti Diza of the Department of Agriculture, Land Reform and Rural Development on the questions relating to Ingonyama Trust and the work of the Special Master of Labor Tenants. You would recall, honorable members, that on the 13th of September in 2022, at a committee meeting to consider our quarterly reports, the committee was dissatisfied about the responses of Ingonyama Trust Board with regard to its performance. This was particularly necessitated by the following: a trend where the ITB, an accounting authority for Ingonyama Trust, does not account on the funds of Ingonyama Trust. It cites the delisting of Ingonyama Trust from the Schedule 23 of the PFMA. Parliament, honorable members, oversees implementation of laws, including Ingonyama Trust Act as amended. One key area of oversight is to assess whether the deserving communities enjoy the material benefit and social well-being from the administration of the trust land. In the absence of the reports, especially quarterly reports about the performance of the trust, there is no way in which we as a committee will be able to make a determination of the benefits accruing to the deserving communities. Honorable members, at the center of this discussion is the separation of Ingonyama Trust Board and Ingonyama Trust. The committee and its predecessor has received a legal opinion that was sought by the then minister, the Honorable Minister Gugile Nkwinti, who was the former Minister of Rural Development and Land Reform, about the existence of two separate legal entities. We would therefore like the minister to assist us as a committee about the government's position with regard to these matters and assist us to conduct our oversight mandate without any hindrance. Recently, honorable members, the committee also learned that the establishment of Ingonyama Holdings, Pty Limited, which is a subsidiary company of Ingonyama Trust, it is of great concern that this oversight committee cannot perform. No, it is with our great concern, honorable members, that as a committee, we cannot perform oversight over that company. And the committee has expressed concerns over the directorship of the company in terms of its transparency around how the directors of the company were appointed and who are the directors for this company. We noted that the AG, Auditor General, also raised concerns about a lack of audit of financial statements of Ingonyama Holdings. Honorable members, we have also noted that Ingonyama Trust Board reported that they were going to appeal the court judgment relating to the residential leases, as well as refunding the lessees. What is the position of the department in this regard? For the ITB, there are about 20 grounds for appeal. If the department seeks to appeal the judgment, what are the grounds for such an appeal? In whose interest is the appeal? Or what does it want to achieve with the appeal? Finally, honorable members, the minister has in the past reported to this portfolio committee on agricultural land reform and rural development.
Recording in progress.
Let's get that out the way. Has reported to the committee at the time it was about to embark on an oversight visit to Ingonyama Trust Board, which was in 2019, that there was an inter-ministerial committee, IMC, which was set up by the president to look at the challenges of Ingonyama Trust. The minister requested the committee to give this process time, and she was to come back to the committee and report. To date, honorable members, the committee has not been briefed about the interventions. And I think at a high level, we would just like to understand what was the role of the IMC and what were its findings. And I think having the minister participating in that regard, we would have a keen interest in understanding what their findings were. The meetings of the 9th and 16th of September 2022 regarding the department, we had presented the progress report with the settlement of labor tenants applications, which left members with more questions about the fast tracking of the settlements of labor tenants' claim. A need for discussion was also necessitated by the following. The recent joint oversight visit of the Portfolio Committee on Employment and Labor have shown that labor tenants and farm dwellers continue to live under precarious tenure arrangements and conditions on farms, and delay in the settlement of their claims, which means that they continue to live under such circumstances. Reports which have been presented show a decline in the performance as the department began to revise downwards the targets it had set. Unfortunately, honorable members, the officials at the meeting appeared to lack an understanding of the complexities of the challenges, the urgency of the matter, and how they would be improving in the delivery of land to labor tenants. In their explanation for the decrease in the performance, they cited reasons that were already highlighted in the implementation plan, thus demonstrating a lack of agency in finding solutions for the challenges. Amongst other issues, one area of concern was failure of the department to produce a specific budget to fund the awards for finalization of LTA claims, despite the court stating that there must be a determination of the budget necessary during each financial year for carrying out the implementation plan, including the Department of Agricultural Land Reform and Rural Development's operating costs and funding for awards made in terms of Section 16 of the Act. Honorable members, oversight visits have shown us that where land has been awarded to labor tenants, it was not complemented with post-settlement development support. There is no internal coordination relating to settlements of labor tenants' claims. Honorable members, I've tried at best to summarize the issues that led to us requesting the minister to come before the committee in briefing us, particularly on the ITB and the Ingonyama Trust issues, which are also related with the Ingonyama holdings. But I've also tried to give a summary of the issues that have necessitated asked to request the minister to also present the matters that are before the special master. I will want to, at this juncture, hand over to the Honorable Minister. But before doing so, Honorable Minister, I wanted to see from the honorable members if there are any other issues on these two aspects that we have requested your presence on, they would want also covered in case I've missed anything. Honorable members, I won't take a round of hands. I'll just look as to who has raised their hand if there's anything they would like to add on what we have been. If there isn't any, you may also highlight that there's none, so we may hand directly to the Honorable Minister. Any hand, honorable members, on any further additions?
Chair, I'm covered. Thank you.
Honorable Ntate Masipa is covered. Agreed, honorable members, are we covered on the summary?
Exactly, Chair, yes, we are covered. Thank you.
Thank you. Let us proceed then and invite the Honorable Minister Mamuti Diza to take the platform and then assist the committee on the issues we have raised. Patiso.
Thank you very much, Chairperson of the Portfolio Committee, Honorable Mandela, members of the committee, senior officials of the department, as well as the ladies and gentlemen of the media whom I've seen on the platform together with the Auditor General present. As Honorable Mandela has already stated, the background as to why the committee requested to have an engagement with the minister in terms of the issues raised. We've made a presentation which we have circulated, and I'll appreciate if that can be flighted. I'm not sure that the Secretariat has it and they can be able to flight it for us. If not, I can speak through to it.
Ralph, can you assist? We have a very competent person in the department, Mamuti Diza, or Ralph, who's always navigating with us through these things and presentations. So I'm certain that he'll be capable to share the presentation. See, taken right out of my lips. You may go ahead, the presentation is on. Can you enlarge the slide, Ralph? Please enlarge the slide. Thank you. You may proceed, Honorable Minister.
Thank you very much, Chairperson. The way in which we prepared the presentation was really lifting on the issues that you have asked us to respond on, and we'll also pick up on some of those matters that you have highlighted as you have been going through. We're giving the status report on the Presidential Interministerial Task Team on Ingonyama Trust and related matters, as well as Ingonyama Trust and its founding legislation, because I think it is important to reflect on that briefly, and the context of the trust itself, and the accountability of Ingonyama Trust, and what are the issues we are reflecting on and what we think ought to be done, and looking at the current governance issues, and also the matter of the litigation which was brought by CASAC versus ITB, and the order that included both the ITB and the minister. If we can move on the second page, just to indicate, Chairperson, that this presentation follows indeed the matters you have raised on the concerns that the department and the ministry may not have done enough to secure the tenure rights of majority of citizens as expressed in Section 25(6) of the Constitution of the Republic of South Africa. In response to these concerns, we've taken a historical assessment of what has been done to fulfill the mandate of the Constitution without necessarily discounting what may be the challenges, Chairperson. Following the democratization of the country in 1994 a number of legislative instruments were introduced to give effect to these provisions of the Constitution, particularly to make sure that there is a tenure security for all. If one were to go through, Chairperson, in 1995, the Development Facilitation Act was promulgated in order to speed up the implementation of reconstruction and development programs and projects in relation to land. In strengthening the rights of these communities who lived on commercial farms and appreciating that these communities may not have adequately covered by any legislation, specific instruments of laws were passed, such as the Labor Tenants Act and the Extension of Security of Tenure Act. The Interim Protection of Informal Land Rights Act of 1996 was also provided, and this act affirms and protects the rights in land by citizens. Further acknowledging that certain land rights had to be upgraded by Parliament, passed the Upgrading of Tenure Rights Amendment Act of 2021. I think it's important to acknowledge, Chair, that this piece of legislation was already there in 1994. However, it did not apply to the entirety of the Republic. It only was applicable to the then South Africa. However, after 1994, its applicability was made to ensure that it protects and it allows anybody in the Republic who wants to upgrade their tenure to be able to do so within the law. There were obviously certain challenges to the legislation, which ended up making Parliament to make the amendment in 2021. Communities living under traditional authorities and a customary land tenure system had their rights affirmed and acknowledged. However, specific legislation was required in order to address issues of ownership, tenure system, and land administration. You'll recall, Chairperson, that in 2004, the Communal Land Rights Act, known as CLARA, was put in place, which provided for vesting ownership to communities and allowed for land administration by land administration committees. There was obviously a legal challenge on the act that was brought by some community members who felt that the section that allowed for the traditional councils to administer the land where the communities failed to establish the land administration committee was unconstitutional. It's important to indicate, Chair, that the High Court ruled in favor of these applicants. The matter was then taken to the Constitutional Court on the basis that there were not enough proper public consultations and proper tagging of this legislation by Parliament to enable enough engagements of those communities who would have been affected by the legislation. The Constitutional Court therefore set aside the legislation and gave Parliament time to follow the proper public consultations. I must say, Chairperson, that unfortunately, it does not seem that following that process, anything was done by Parliament then, nor initiation by Department of the same legislation once again. Trials were done in 2016, and in 2017, the process was also stopped, which then created a vacuum, if one were to call it that way. But it's important to then indicate what has been done by the sixth administration to pick up on that issue once more. We had started the process of policy formulation as well as the legislative review to address communal land tenure. Consultations have been done with traditional leaders, rural communities, academia, and non-government organizations, which finally culminated to the hosting of the Communal Land Summit in May 22. I must say, Chairperson, that this summit has dealt with issues of community ownership of land and a customary land tenure system. We are currently having a draft bill and policy which will soon be presented to Cabinet in order to allow for public consultation. We're just waiting for the pre-certification by the state law advisor, who will then look at whether the law is in line with our Constitution. I think it is important then, Chairperson, this background, I thought it was important just to give the historical overview of what has been done. Yes, it may not have been enough, but it does indicate the journey we've traversed in trying to ensure that everyone's tenure security in our country, acknowledging the tenure systems that we have are protected. If I were to come to the matter of the Presidential Interministerial Task Team on Ingonyama Trust and related matters, Chairperson President Ramaphosa set up the Interministerial Task Team in 2019, whose responsibility was to prepare for his engagement with the King of the Zulu Nation following concerns that were raised by the King as to whether the proposed expropriation act without compensation was to impact on land under Ingonyama Trust. But also there were concerns that were raised regarding the statements that were made out of the Motlanthe high-level panel report, which certain statements were made regarding the role of traditional leaders and more in particular on the Ingonyama Trust land. This IMTT included not just ministers in the national government, but also the Premier of the KwaZulu-Natal province and the MEC for Human Settlement. In their reflection, it needed to also address matters that impacted on the townships, particularly 239 townships, those that were under Ingonyama Trust land, and how these may be dealt with in accordance with the legislation, particularly if you look at the Ingonyama Trust Act, which provides for the board, it indicates that all of those townships that were on Ingonyama Trust land prior to 1994 must be assumed or acknowledged as vesting to the local authorities. But there were issues in terms of actually making those matters understood by both parties, which then required engagement between Ingonyama Trust and the relevant MECs and the province of KwaZulu-Natal. The Interministerial Task Team recommended that with respect to the proposed expropriation without compensation, this would not affect the land under Ingonyama Trust. On other matters, the view of the IMTT was that the relevant ministries and departments must address those matters with Ingonyama Trust and Ingonyama Trust Board specifically. These issues related to the rates and taxes for government buildings on Ingonyama Trust land and the townships that are on land under Ingonyama Trust, as I've indicated. The details of the report and other matters that the President had requested the IMTT to look into will be actually tabled to the President in this regard. The IMT's views, however, on the matters of the high-level panel, specifically relating to the Ingonyama Trust, was of the view that these matters should be addressed through dealing with broader policy issues on communal land tenure. If I were to now move, Chairperson, on the founding of the legislation of Ingonyama Trust and how it was constituted, in our presentation, we actually give a historical overview of the creation of the trust, because we think it's relevant for all of us to appreciate the complexities around this trust, because it's not consistent with how other communal land or land under traditional areas were actually dealt with in the transition before 1994. Presentation will also reflect on the amendment that provided for Ingonyama Trust Board of 1997, and further the issues of accountability of Ingonyama Trust Board, which we will lift from where we sit, Chairperson, on matters that we've been grappling with and how we think these must be addressed going forward. And lastly, on matters of litigation against Ingonyama Trust Board, which the Minister was cited. If one were to give the context on Ingonyama Trust, it's important to appreciate that in April 1994, all homelands were abolished and incorporated into South Africa as a unitary state. All land owned by those governments of those territories was then vested in the new national government. However, just before the interim constitution came into force, the then government of KwaZulu-Natal struck a deal with the government of the Republic of South Africa under the leadership of the National Party to establish the trust and to transfer all the land held by the then government of KwaZulu to the trust. In April 22, 1994, the Trust Act was passed by the Legislative Assembly of the former KwaZulu territory. On 24 April, this act was then approved by the national government, its president declared at the time, of the self-governing territories. The trust was to be the custodian of the land that was previously administered by the defunct KwaZulu and Natal government. And you will see in the attached legislation, it cites various communities that will be affected by this legislation. The title deed to the trust held land was therefore endorsed, vesting all the land in Ingonyama and the trustee being the king on behalf of the members of the various tribes and communities and residents thereof. The land transferred to the trust was not only tribal land, but it also included, as I've indicated earlier, some of the townships within the jurisdiction of the government of KwaZulu-Natal at the time, with the exception of land that was already privately owned. It is against this background that the trust is presently the registered owner of approximately 30% of the land in KwaZulu-Natal. The Trust Act remained a provincial act until 1997, where it was amended by National Parliament. As a result of this amendment, the trust acquired the status of National Act. Section 28 of the Amendment Act created the Ingonyama Trust Board to administer the affairs of the trust and the trust-held land, supporting, as the legislation says, supporting the trustee. I'm raising these issues so that we can actually get the appreciation of the history of the formation of Ingonyama Trust and the land under it. Over the years, there has been issues of accountability, Chairperson, as you correctly have raised them. And in our view, the accountability of the Ingonyama Trust Board must be measured by its compliance with the financial management legislation, given the public resources that are given in the trust in supporting its work. Secondly, the accountability of the Ingonyama Trust Board must be measured by how it supports the trustee in the management of the trust land, as well as the beneficiaries residing in such land on how they benefit from it. In its inception, Chairperson, the board was supported by the personnel from the Department of Land Affairs, given that the board is not a full-time entity, and its task would be to ensure that those employed undertake the functions that must be executed by the trust. Over time, however, during 2008, 2009, the board was then given seed capital to actually appoint its own staff, because the department was not able to continue to do so and was not able to replace its members as they retired or they left employment of the department. It must be indicated, Chairperson, that over the years, one of the issues that had actually challenged the board is its maintenance of its human resource capability against the resources that the board has. And I think also the tension which I'm sure led Minister Nkwinti to look for legal opinion is, where should this lie? Should that be in the trust, or should it be the staff of the board? And I think that matter, Chairperson, as you have correctly raised, has not yet been resolved, given that if you look at the character of the board as it was set up, it's not very clear as to what is the delineation between itself and the trust, which is a matter that we're grappling with, Chairperson, and we will be putting our recommendations to Cabinet on what we think ought to happen. If it requires amendment of the legislation, this will actually be undertaken and brought to Parliament. Over the years, it is important to indicate that the board has also, as part of its support to the trustees, to the trust rather, ensured that it sets out lease agreements with those who undertake business in the Ingonyama Trust land. The board also has facilitated, where necessary, the allocation of servitude under Ingonyama land, particularly when one look at the issues of electricity and water and other network industries where such servitudes are required. And those entities will then pay, or expected to pay, the Ingonyama Trust for those lines of servitudes that have been allocated. In its functions, the board has also initiated surveying on some of Ingonyama Trust land in addition to the earlier surveys that were done. It has also done improvement as per request from the said Amakosi under Ingonyama Trust land, where requests might have been made for the improvement of one or the other or support of those communities for matters of development or tractors and so on. However, it is important, Chairperson, to indicate some of the challenges that in the 6th administration we have picked up, and some of those have ensured engagement between ourselves and the board as the ministry and department. It had become clear to us that it does seem that the mandate and the role of the board vis-a-vis the broader obligation of the trust is somehow muddled. And in the 2 engagements we had with the board was to really try to clarify this, because in our view, this is what also creates challenges in terms of financial accountability in particular. Also, the other challenge that we have identified has been the role of the Ingonyama Trust Holding and how this was set up and its accountability. As you will appreciate, Chairperson and honorable members, in terms of the current legislation that provides for Ingonyama Trust and Ingonyama Trust Board, it does not provide for the Ingonyama Trust Holding. And I think this is the matter, and as the Auditor General might also reflect, has caused several engagements between the Ingonyama Trust Board and the Auditor General as to how the treatment of such a trust, or rather of such a holding of the trust, needs to be dealt with, both in terms of its auditing, but also in terms of its accountability and disbursement of those resources. The leases on residential properties has also been one of the matters, Chairperson, that has been identified even before the case was brought by CASAC and the conversion of PTO. It does seem that there was no clarity as to how the agreement was reached for the conversion of PTOs to leases, and therefore how those are administered, whether are they long-term lease, are they done for business entities or even the households. The other matter was our concern, the disbursement of resources to the beneficiaries. As I've indicated, Chair, one of the things we've identified is that, yes, there have been disbursement of improvement in the jurisdictions of Amakosi under Ingonyama Trust, but no clear policy as how this disbursement of resources, for instance, are being made. One of the issues we've been reflecting and engaging the board on is when you lease a particular piece of land under the community of Ematunini, if I were to use one community, does that resource go to the account of Amatunini tribe, or does it go to the Ingonyama Trust Board, or does it go to the Ingonyama Trust Holding? If it goes to the holding, for instance, how then does it get dispersed to the community of Amatunini for it to be able to undertake any development? And that lack of clarity and policy has been an issue that, in our view, the board needed to clarify, because it does cloud, how disbursements are made. The board has actually raised a concern that in respect of the disbursement, part of the challenges is that the old traditional authorities under the then KwaZulu government and the new TLCs, transitional councils rather, in respect of the new administration, are not congruent, and therefore they still debate between the board and the COCTA to say, how does this get resolved so that disbursement can be done? But in our view, this matter must be immediately resolved, because a lot of resources are actually locked in the holdings and it's not transferred to the then communities. But also it does not seem communities themselves are clear as to how they can request resources for their development on the land under Ingonyama Trust, on the resources that accrue from the land that can be utilized from their land. One of the issues in our view that we felt we needed to address, because all of these issues in our view indicates challenges of governance. It has been clear that there are issues of governance that needs to be addressed. For instance, if you look at the way in which the Act provides for the appointment of the board, you've got 4 members of the board that the minister must appoint after consultation, and you have got 4 members which the minister must appoint after the premier of the province has consulted with the House of Traditional Leaders in KwaZulu-Natal and Isilo, and then thereafter, when there is that agreement, those members can then be formed, and then the chairperson becomes the nominee appointed by the Isilo, which again creates a little bit of challenge when it comes to governance matters, because even that consultation is a bit nebulous as to how you can say you have consulted enough. So these are the matters in our view that we think needs to be addressed in terms of governance. A compact also, we feel it's necessary between the minister and the board so that it addresses clearly what the minister's expectation is on the work of the board. Can you please go back to that slide, Ralph? You've moved quicker. Yes. We also feel that the new board, once it's appointed, there has to be an induction based on the compact so that there is no ambiguity about issues of mandates and accountability as it has seemed. We also feel that the appointment of the new board, in our view, needs to be transparent. What we've done, we have actually advertised for nominations. We've done interviews after shortlisting. We have then made recommendations. And I must say that, unfortunately, it has delayed. Only yesterday, we received the letters both from the Premier and the Chairperson of the Provincial House on the response on the consultation on the 4 members. And there are 3 recommendations that have been made on the other 4, which the Premier will then have to consult Isilo and come back to us with those recommendations. And in our view, we will be finalizing that process very soon. We also feel, as I've indicated, that there should be clearer policy on disbursement to communities of the resources from the Ingonyama Trust are accruing out of the benefits that have come from the land that has been leased in Ingonyama Trust. Chairperson, if I may move to the next matter, which relates to the case CASAC versus ITB. The matter, as you all know, is that the court found in favor of CASAC on the matters particularly relating to the leases, that these leases must be paid back to those who have paid it, particularly for residential purposes. The minister thereafter wrote a letter to the board indicating that the board needs to comply with the order. However, the board as a juristic person decided within its right that it would actually apply for an appeal of the judgment in its entirety. In May 22, the High Court granted Ingonyama Trust leave to appeal against the entire judgment on the basis of all the ordinary legal grounds of appeal that were advanced by the Ingonyama Trust. I need to indicate, Chairperson, that the minister did not appeal because we did not view it necessary that we should appeal, because we believe what the court had indicated needed to be complied with. However, the minister, not being the one that was charging the lease could not do anything beyond asking the board not to appeal. However, as a legal entity and a juristic person, the board decided that it would actually appeal the judgment. In August 2022, the Supreme Court of Appeal dismissed Ingonyama Trust application for leave to appeal on recusal grounds. This does not impact the main application, though, where Ingonyama Trust was granted leave to appeal based on other ordinary legal grounds of appeal. The said application is still to be heard by the Supreme Court of Appeal. In September 22, Ingonyama Trust approached the Constitutional Court for leave of appeal against the order of the Supreme Court of Appeal on the recusal ground. This application is still to be decided by the Constitutional Court. In view of the fact that Ingonyama Trust is still contesting the entire judgment of the court, it actually prevents the minister to actually undertake certain steps, particularly that relates to the termination of the leases and other matters, to be able to do what the court has asked us to do. However, I must indicate, Chairperson, that on matters that related to issues of delegations, where the legislation was actually delegated to the provincial MEC of COGTA, the minister has acted in that respect. We've actually worked with COGTA in the province, who had indicated to us that they don't have capacity to continue with the delegation. So we've taken back those delegations and set up the system of how we can actually manage that legislation in its entirety. We have responded to the court on the matters that they that asked us to deal with, which are not impacted by the broader legislation, order rather, that is being challenged. We can move on the next slide. Well, I think I won't go through that because it's just the order as it's stated. Chairperson, we can move on the next slide. Let's move on the next slide, Ralph. Actually, that matter, Chairperson, relates to what I've already said, that the minister has withdrawn the delegations to issue permissions to occupy from the member of the executive of cooperative governance in KZN. The department and COGTA have verified all the PTOs that were issued by COGTA up to 2007. It was further verified that since 2007, COGTA had stopped issuing PTOs, and these permissions were issued by Ingonyama Trust. As a department, we've made provisions for a fully fledged directorate of communal tenure with the subdirectorate at district level, so that indeed we can comply with the order of the court to ensure that the issues of management of land under traditional communities, not just in Ingonyama Trust alone, but across the country, is actually dealt with. As we know that in the various provinces, these PTO were either handled by the departments of agriculture, in others actually there was a vacuum as to who is the authority that is going to address that matter. So these are the matters that we are correcting following the matters of court. Chairperson, I will then ask the department, or maybe Vela, just to deal with the issues of financial accountability. But this is the broader presentation that deals with the historical, but also with what we are doing in terms of intervening in addressing some of the questions that Chairperson and the members have actually identified, even on your oversight in respect of this manner. Vela, I'm not sure whether I would like to come on the issues of the finances or DG.
Thank you, Minister. I had not prepared to come through to say anything, but Chairperson, thank you so much. With respect to the issue of accountability, in terms of the way in which the board has dealt with the issue of accounting for finances, the committee is aware that the board's responsibility is to administer the affairs of the trust, essentially is to administer the trust, because the benefits are issued by the trust to the beneficiary communities. So when Ingonyama Trust Board compiles the financial statements of Ingonyama Trust, part of what you'll see in the Ingonyama Trust financial statements are disbursements. It may well be an issue of maybe a little bit more information would be required by the committee in terms of who or where did those disbursements go, because those disbursements are disbursements to traditional councils. Yes, there may be weaknesses in the sense that when a traditional council has requested a disbursement, money gets dispersed to the TC. As to how does it flow from a TC to actual members of a community, that's a process that gets managed by the TCs. So maybe there could be an issue of weakness with respect to that. I think on the issues in as far as they relate to Ingonyama Trust, Ingonyama Holdings, I don't think it's an issue that I would want to go into. Maybe members of the board, those who are on the platform, may have to address it. Thank you so much, Minister. And thanks so much, Chairperson.
Thank you, Chairperson. We finished the presentation. There are members of the board of Ingonyama Trust, and maybe when the committee reflects on this issue, they would also be able to respond.
Thank you, Honorable Minister. We also want to thank Advocate Mgwengwe for his input and welcome all the officials of the department and members of Ingonyama Trust Board and Ingonyama Trust onto this portfolio committee meeting. Honorable members, there is the presentation and responses from the Honorable Minister Mahmoud Didiza on the issues that we wanted to engage on. We'll now open the meeting for discussion or questions of clarity. Honorable Kabe. Honorable Kabe. The Honorable Mamumba Bama. The Honorable Mamumba Bama.
They are not on the platform, Chair. Both Mamutlape and Mampapama.
Honorable Trede.
And Trede as well, Chair.
Honorable Matiasa.
Good morning, Honorable Chair Talipunga, and greetings to the Minister and the colleagues. Am I audible, Honorable Chair?
Yes, we are audible.
Well, look, let me welcome the presentation by the Minister and really express our appreciation. However, be quick also to point out that this report has long been awaited for. It would have been good if we received it whilst our energy levels were high. We only receive it now towards the end of the year. However, Honorable Chair, let me highlight that our interest in insisting that we need this kind of a report has been twofold. First is to ensure that there is proper good governance principles that are observed by the Ingonyama Trust, and ensure that, secondly, that there is proper fiscal accountability on the affairs of the Ingonyama Trust and the Ingonyama Trust Board. Those are the main two reasons why we really needed this report. But over and above the governance and fiscal accountability aspects, what bothers us most is the continuing complaints from our people, who are the people of the king, who are residents and citizens, over complaining about incidents that occurs repeatedly of harassment and victimization on the land that they find themselves through the system of insecure land tenure, which is the aspect which the minister addressed, the PTO system. So there are three concerns, of course, we would want these to be addressed. Amongst them, of course, is the issue of providing our people with a better, improved tenure system, especially women and those families that are child-headed as a result of the passing away of either the father of both parents. And women continuing to be victimized and be deprived of their right to occupy land and to enjoy, derive benefits from land. Now, having addressed these matters and having them being ventilated now in this meeting by the minister, we will really need to see some progress in respect of these aspects, the good governance aspects that the Ingonyama Trust Board and its what is this? The vehicle that they have established recently, the PTY company, must really observe the prescripts of the law, the Public Finance Management Act, and ensure that it opens its book for public scrutiny. Ensure that it submits its annual reports, its annual financial statements accordingly. Ensure that those who transgress on the provisions of the Public Finance Management Act and other prescripts are brought to book and held to account. Because money that comes from the department to the Ingonyama Trust Board, or even the revenue that is generated by the Ingonyama Trust itself, is public money held on behalf of the public by Isilo Samabar through the Ingonyama Trust Board. So even if that money is generated through other revenue generating methods and systems, is public money, it must be used as such and not for other reason other than the development of the people in KZN, where the Ingonyama Trust Board has jurisdiction. I think for now, Honorable Chair, we didn't want to be adversarial with this engagement. We would want to be as constructive as possible to ensure that we get the best out of this interaction going forward in the new year and beyond. We want the best model of land ownership, land management system under our traditional form of governance, which serves the people from which the people can accrue the best benefits that take care of their children, take care of their future, take care of their well-being. That's what really drives us, nothing more and nothing less. And I hope that in your opening remark, as I was listening, you echoed these views, Dalibong. And for now, I want to pause and listen to other members as they make contribution. Thank you so much.
Thank you, Honorable. Thank you, Honorable Tate Matthias. The Honorable Baukapa.
Thank you, Chair. I don't have anything much to ask, except maybe to make an emphasis that, in my opinion, maybe that's what has to become very, very clear, is that in the process of financial accounting, it must be clear for us as the committee if there are any part of funds or any funds that may not be accounted for to the committee. And maybe to be clear on that part, that which are these funds and for on what grounds, so that in future, when we engage, we should not find ourselves in a situation where it looks as if we want accountability on what we do not deserve to get accountability for. Just on that part, Chair, I think it is also linked to what Honorable Matthias was saying. I thank you, Chair. Otherwise, for the moment, I'm all right.
Thank you, Honorable Baukapa. The Honorable Tate Masipa.
Thank you, Chair. And once again, good morning to colleagues and the Minister. Minister, thanks for the presentation. Really, Minister, and Chair, we requested obviously this presentation of the appearance of the Minister because the committee for a while has been at loggerheads, and we had kind of an estranged relationship between ourselves and the Ingonyama Trust. And Chair, on several occasions, you will recall that the Chair of Ingonyama Trust was quite clear that the members of this committee do not understand the legislation that is governing the trust. You will recall that during the previous term, the committee of that term, they have sought the advice, legal advice, and the feedback was clear that the Minister bears all ordinary and public finance accountability in respect of the trust and the board, quote unquote. Our issue, and obviously the AG issue, has been the management of finance, and some of the people living in this ITB land held properties has been the issue of finance, the management of finance. And I'll just like to quote the judgment of eThekwini municipality, not the application. In 2013, eThekwini municipality brought an application in KwaZulu-Natal High Court seeking a declaration that Ingonyama Trust property falling within the jurisdiction of the municipality is rateable for a period between 1996 and June 2005. However, the trust opposed the application and contended that the land was state property, which was exempt from being rated in terms of rating of State Property Act, Rating Act. Recently, Chair, the eThekwini municipality has once again reiterated that it intends to go after affluent residents who live on Ingonyama Trust land and should be paying the city for services. In 2020, rural women who were tricked to sign lease lodged a court challenge against ITB, and the women won their case, and ITB challenged the outcome of this court case, and the SCA dismissed ITB's bid to overturn the lease program ruling. Leases were ruled invalid and millions must be paid back. Millions of rents must be paid back. The question, obviously, to the Minister and maybe the Ingonyama can really assist us here, is what intervention, Minister, have you taken to ensure that these women that took the Ingonyama Trust to court in order to get them reimbursed? And obviously also the second one is, can the minister provide us clarity on how ITP can collect leases and at the same time find it correct to challenge eThekwini municipality when it seeks to collect the very same leases that ITP is collecting on the Ingonyama Trust land? Msunduzi municipality also, one case was taken to court by ITP after the municipality disconnected water and electricity due to non-payment of the 8 million rands. While persons living under traditional authority rights have been affirmed, as you have indicated, Minister, I think the issue remains over the ownership and tenure system. With the case of Msunduzi, don't you think that if the tenure system is corrected and people who choose to have, obviously, title deeds or other means of administration can live a life of less interruption as a result of, the challenges that ITB might find itself while, you correcting the issues there at ITB, and especially, the basic honoring the water and obviously the electricity bill, which I would assume that the ITB collects and obviously pay the municipality or pay the ESCOM as such. Just the last one, Chair. Minister, you spoke about the draft bill emanating from the Land Summit in May 2022. Does it provide an opportunity for those who want title deeds or any other, call it the tenure system to get them as such? And what are the timelines in terms of introducing this particular bill? Thanks, Chair. I think that's all I am done.
Thank you, Honorable Ndate Masipa. The Honorable Memasho.
Honorable Chairperson, our Minister, our colleagues, our officials, members of the board present. Chairperson, I would like to indeed welcome the presentation by the Minister. One will say that indeed today it has helped us to understand the most important issues on this ITB. The presentation indeed made some of us to really know what is happening and what should happen and when and how. Chair, it is long that we have been waiting to hear this type of presentation, which will help us really indeed to understand the issues, because we've been, I don't know whether I should say, but let me put it in this way. We have been insulted by the board. When a person says you don't understand the law, and when on the other side you have been elected to be a lawmaker, and then somebody tells you that you don't understand, you don't even know what we are talking about. It was an insult to us. But today, I think, Minister, you have made us to understand really that it was not that we don't understand. It's just that this issue started long ago. We wanted somebody to bring us on board like you did today. Although you have been there, my Minister, you have been trying to help us. But I think me, personally, today, my ears and my eyes are open. I can be able to deliberate on the issues of the ITB. And thank you very much for the work that we have done today. Is well presented. Keep it up. And our officials, your notes are very good, and we thank you very much for the hard work that you have been putting in trying to make us to understand what is happening with this issue. But I think at the end of the day, Honorable Minister, and the Honorable Chairperson and all the administration, including our committee, we need to make sure that we worked on this matter so that it can find its closure. It can find its right place to be addressed, and we get the right things, and with this matter must be settled. We can't be having one issues on the table all the time. And if you see people are not on the platform, no one who wants to say something because we feel insulted. So we thank you very much, Honorable Minister. It won't be good if all of us we can go out of the system because we are running away from being insulted by the board, that we don't understand what we are doing. They don't want even to take us through. But today, Minister, I think you have addressed everything. Chairperson, thank you very much for your summary. When you give your input, when you started this meeting, definitely sure you have also touched a lot of information that indeed, as the committee, we have been trying to get help on. Thank you very much.
Thank you, Honorable Memahlo. We hadn't come to the end of the meeting for a vote of thanks. I will be keeping that in mind to give you the platform for that. Agbare Breed.
Môre voorsitter.
Hoe gaan dit vandag?
Goed en self.
Dis baie goed, man.
Ek's bly om te hoor. Chairperson, I want to thank the Minister for this presentation and for the committee, for your good self, for actually having this meeting. I think it's good and I think it is long overdue. But I think I have to agree with Honourable Matthias in saying that it would have been great sooner in the year, not as we are winding down. But Chairperson, maybe let me get to my questions. A lot was said about the ITB and the department to consult on the legislative mandate of the ITB to clarify the responsibility of ITB as the administrator of the trust and trust land, how to deal with leases and pledges, the disposal of Ingonyama Trust land. And there was made mention that parties would develop a common understanding of the Act, their responsibilities in context of the Act, and then develop policies to guide on how the trust would be managed to ensure transparency to stakeholders and Parliament. And I would like to know, how far have we gone with this undertaking? How far is it? And I think, Chairperson, that is one of the main things that I picked up in this presentation is the whole time there was made mention of clarity issues, locked land that was locked into holdings that cannot be released, and new policies that will be developed. I think Honourable Masipa also made mention of new bills, or amendment bill that is in process. And I think my one critical thing is I've written down how far, what is the time frame, how and when will we resolve these issues. So Chairperson, I think it would be very important for the Minister to all of these issues that she has made mention of, these policies that she has mentioned will be developed. It has said that with the new board, we will sit in discussions. And I think that is great. And she's now made mention of the fact that there was problems and that the process to actually appoint a new board will be a bit delayed and not due to in the initial time frame. And I would like to know when that time frame is. What is our new time frame we're looking at the board? What is our new time frame for these policies? How and when are we going to resolve these issues? And I think all of these issues made mention, we need to see a time frame. Are we looking at a 1 year, at a 2 year, at a 5 year, at a 10 year, at a 20 year project? Because we're running to the end of this term of the 6th Parliament. My fear is that we will not see these legislation, we will not see these policies, and come the 7th Parliament, we will be having this again. And then, Chairperson, maybe just, and this is a question that arises because the ITB said that it only accounts to the department in terms of transfers. and there was issues regarding that. And I would like to know in what ways does the minister oversee the trust operations? Have they come to a understanding in this? Is the minister clear on this? Is the ITB clear on this? And can we be made clear of this? I think that is very important, Chairperson. And then I think I will, disbursement policy also was, how far are we? Chairperson, I will leave it at that. Thank you.
Thank you, Akbar Brett. The Honorable Mema Hlati. Mema Hlati. Dabezita Koseku, the Honorable Nkosi Tebekulu.
Thank you, Honorable Chairperson. Thanking the Minister for the presentation that she has made before the committee. Although one does not have questions, Chairperson, but one needs to raise one or two things. We are where we are with the different views from how the ITB operates. In my view, it started simply because there were people who went out to borrow funds from banks to build their houses, and for their security, they applied to the ITB in order to get the leases, so as to guarantee that the land that they're building on is protected. Now we are getting, as the views are coming up, that the municipalities wanted to charge the rates from the ITB simply because it is in charge of the land under Ingonyama Trust. It's simply because of those that went as far as going for the leases. But as far as the minister has just explained, I think one gets sort of an understanding and covered, because it shows how deep the minister has gone through in order to establish the facts around the operations of the ITB, which, in my view, as one of the trustee leaders, had no problem with the way the land is administered in the areas of Fomakosi. The fact that some people are coming up with the allegations that the widows don't enjoy the privilege of owning those pieces of land when their husbands passed on, things that are being created by certain people somewhere to say women are treated that badly. It's, even though it does happen, it is not in a majority. Just a few areas and tribal authorities that might be found to be doing all this. But one will be looking forward to getting a sort of a deeper understanding as far as maybe the ITB goes, as far as the issue of the ITB holdings and the rest. Because the understanding is that in my understanding, in every trust, the trust does have the right of generating funds in order to manage its affairs. This is what, Chairperson, I feel I should raise, but not questions, but the views that I'm having with regards to how the whole issue of the Ingonyama Trust was formed, and for what good reasons was it. You know, Chairperson, looking at how things are happening when it comes to minerals, you go to the other areas of the communal land under administration of Fomakosi, you find these big companies mining coal in the areas. They leave the areas very, very badly rehabilitated. More especially those that are dealing with cold. They live areas very unhabilitated. Those are the things which we should actually be a responsibility of certain departments who are responsible for the royalties and taxes on those land. But with the issue of the Ingonyama Trust holdings, I think one would be looking forward to hear deeper on how then it's going to be operated. Thank you, Chair.
Thank you, Tabezit. Siyabulela Nkosenkulu sibamba ngazo zombili. The Honorable Ntate Montwedi.
Ke a leboga modula stilo e re ke go dumedise botlhe ba ba leng mo kopanong tsatsing la gompieno. I think for almost 3 years now, we could not do anything with the Ingonyama Trust because we were told that there's a ministerial committee that has been established to deal with the issues of the Ingonyama Trust. And it's been quite long, Shane, and it's seriously worrying, Chair, that we're sitting here today. I'm really not sure what is it that the ministerial trust team has done in terms of resolving the issues of the Ingonyama Trust, because I thought one of the things that the ministerial committee was going to do was going to really have a discussion with the board of the Ingonyama Trust or anyone involved in the Ingonyama Trust there and really explain to them that in terms of the act that has brought about their existence as a trust, they are obliged to comply with the various pieces of the legislation, in particular the PFMA, for them to account on finances of the trust. So I tried listening into the minister, but from what I'm picking up, I'm still picking up that I really don't know what is the work of that ministerial trust team. What have they achieved, Chair? Now, the board remains refusing to account on the affairs of the trust, which is a very, very serious concern, Chair. And I've heard the minister around the issue of the board, the process, appointment, there and there. But I want to check, Chair, something to say. There was Advocate Mugwege, who's on the platform, who was representing the minister in that board of the ITB, who resigned or was removed. Can we be taken into confidence as the committee as to what actually led to his resignation or removal? Or could it also be the fact that the board believed that no one else can play any role in the board except them as members of the board? But if anybody comes from the side of government saying this is what must be done, what actually informed the resignation and or withdrawal of Mr. Mugwege from the board, Chair? But like all other members have said, up until this thing is resolved, there's nothing that we can say because we can't keep on saying the same thing over and over again. We've got entities of the department that comes and account and not even question our role that we have to play as a portfolio committee. And we have this very entity that has continuously questioned and undermined the authority of us as members of parliament who are serving in the portfolio committee. I don't know what relations do they have with the minister if they have if they can undermine us as members of the portfolio committee. It means they don't have any relation with the minister. So I'm just not sure, Chair, where to start, what to say, but I must just raise my concern with regard to that and hope that this matter must finally come to rest so that we focus on making the board to account on the use of public funds, because that is the role that we're here as portfolio, as a committee. We can't have one entity that, just give us a runaround, that we can't make them to be held accountable. They're saying you can only hold us accountable to this far, but you can't go to this far. Why is that the case? Thank you very much, Sheikh.
Thank you, Honorable Tate Montwedi. The Honorable Baukruger.
Thank you, Chair. No, I'm covered. I think everybody spoken and spoken a lot of sense. Yeah, I'm also concerned about our role to do oversight over public money, but I'm covered. Thank you, Chair.
Thank you, Honorable Bao Kruger. Honorable members on the platform, is there any other honorable member who wishes to pose a question that I have not been able to recognize?
Honorable Thape, Chair.
Yes, Honorable Methape. Please
Sorry
proceed.
for joining late, and I risk repeating what other members have said. Chair, to avoid repetition, let me also welcome the presentation on Ingonyama Trust Board. It's true that we've been having issues as a committee with this trust board. And I want to agree with members that are saying the sentiment that ours is to deal with the accountability of this entity. We cannot run away from holding them accountable. Having said that, Chair, of the opinion that for the fact that we have put ITB under our spotlight, it should have a program on this committee of always tapping onto it, because we always get frustrated at the end of a quarter when they come to report. Now, this thing of waiting for the annual report, for the quarterly report, does not work for us. Let's have a program of making sure that now and then the minister comes and briefs us on what is going on the ITB. The issue with the ITB also, that we need also to take into consideration, just put on the back of our minds, is that we're not the only stakeholder on ITB. Hence, it will be very prudent that as this committee, we focus on them accounting to us. And that we will do together with the Auditor General. We will understand that recently the AG bemoaned the issue of the subsidiary that they have that could not be accounted for. And that should be our focus, so that we bring this thing of accountability to the fore, and then we take it from there. That will be my submission, Chair. Otherwise, thanks for the clarity that the report from the Minister has shed light on. Thank you.
Thank you, Honorable Thape. Honorable members, any other honorable member on the platform who may wish to pose a question? If there's no other honorable member, let me also, honorable members, welcome the input as put by the Honorable Minister, as well as Ubao Umgwengwe, in regards to the matters pertaining in Ingonyama Trust, as well as Ingonyama Trust Board. We welcome, honorable members, the program that has been made with regard to the development of communal land tenure, policy, as well as legislation. In the discussion that the department has had, where do you locate Ingonyama Trust and its ownership of land? I raise this, honorable members, in relation to the issues of the legal opinion. The minister said they are grappling with at the moment. The legal opinion was obtained in 2017, and 5 years later, the matters have not been settled. They are going to make proposals to cabinet, is what the honorable minister has said. What are those proposals that are being made to the cabinet? In the meantime, our oversight status quo remains. We are tasked, honorable members, with a duty to carry on our mandate of doing oversight on the ITB. So we would like clarity in that regard. Honorable members, with regard to the question of accountability of the trust, the chairperson of the board has said on numerous occasions that Ingonyama Trust has been delisted from the PFMA schedules and does not account in terms of PFMA. Further, that the Ingonyama Trust Board fully accounts on the transfers from the department. It is this issue that the Portfolio Committee on Agricultural and Reform and Rural Development is concerned about, where an accounting authority for a public entity decides that it will not fully account on the finances of the entity it is supposed to account for. We would therefore, Honorable Minister, request clarity in this regard. But I must also add, because as the Honorable Inkosi Kabekulu says, he's a traditional leader in KwaZulu-Natal and grapples with some of the issues that have been raised. I, for one, as a traditional leader that has been close and working closely with traditional leaders in KwaZulu-Natal. Many of the traditional councils where the Ingonyama Trust levies monies from have never seen a cent of delivery being contributed to their communities. Further, the problem is exacerbated by the fact that if you look at the monies levied from these communities, and I would simply do a simple figures of, let's say 10 million has been raised from these communities. The ITB says that they contribute 90% of those funds to those communities. And they keep 10% for administrative purposes. On numerous occasions when you engage with the traditional leaders, such as Unkosi Mkhize, they would attest that they do not even know the amount that is levied in their community for them to even make requests to the ITB. So if the levy has been 10 million rand that has been levied out of the entire community or the specific tribal council, you then have them making a request and they make a request for 1 million rand. The balance of that is never disclosed to them being 8 million rands, if indeed 90% of the funds are supposed to be utilized on that traditional council. So you would get a community hall for 1 million rand speaking, and you'll never be disclosed the rest of the amounts. This is the exact issue that we are trying to grapple with as a committee as to, can we have a total disclosure from the ITB on the projects that they are supporting of Amakosi in their traditional authorities? But most importantly, it is, what is the levy that is levied in each traditional council and what is spent on each traditional council? That will be all on my side, honorable members. We'll now hand back to the honorable minister and the executive, the officials of the department, and members of Ingonyama Trust. Thank you.
Thank you very much. Nkosi and Ndabezitha. I will respond on the issues that have been raised and give clarity on some of the questions that have been raised by members, but also note the comments that have been made. I would also ask the board to actually respond on some of the specific matters that has been raised by honorable members. Maybe just to appreciate the support that the board, the committee is giving on some of those matters that we clearly feel need to be dealt with in response to how good governance principles need to be observed by Ingonyama Trust Board, including financial accountability, as well as appreciating this dilemma of an entity which is a subsidiary of the board. However, its financial accountability and general accountability is not actually allocated properly, which is an issue that I've raised in the presentation that has been an Achilles heel between ourselves and the board. And I just want to indicate, Chairperson, maybe just clarifying the issue that Honorable Ntwedi has raised. Even from the beginning, we did indicate that the IMTT was appointed by the President in preparation of the meeting with the King. And as I've clarified what that, as a member of that committee, what it arrived, it was not dealing with issues of accountability of the Ingonyama Trust Board and all other matters. And in the report, Honorable Ntwedi, I have indicated exactly what that IMT did and responded to the President as such. But the IMTT was very clear that the ongoing matters relating to the governance, accountability of the board must be dealt with by relevant ministries and departments. In respect of matters of the townships, 239 townships in KwaZulu-Natal, those will be dealt with by the MEC in KwaZulu-Natal of Human Settlement together with the province. So I really think it's important to make that emphasis once again, because the role of the IMTT was not dealing or was about to deal with issues of Ingonyama Trust per se, but it was in preparation of the President's meeting with the King arising out of the issues that were raised by the high-level panel, as well as the issues that emanated from the ANC's resolution, which further was then tabled as a proposal in terms of Parliament as a motion by the EFF, amended by the ANC on the expropriation without compensation. I think it's important also, Chairperson, to indicate on the issues that you're raising that that's exactly why in our presentation of how we need to resolve some of these matters is to deal with the disbursement policy of the Ingonyama holdings. As you say, Chairperson, you are correct. Same frustrations that ourselves as the Ministry and Department has been having to understand how do these communities actually benefit. And as I say that when we engaged with the board, the Chairperson of the board cited the difficulty of disbursement based on the issues of the configuration of what was traditional authorities and what is now traditional council, which he stated that they are still engaging with the province of KwaZulu-Natal to deal with those matters, which clearly means a lot of resources are still stuck in the Ingonyama holdings, have not actually been entirely dispersed. And without the disbursement policy that is clear, you will never be able to have clarity by communities and their chiefs as to how do they draw those resources, how much is levied from them. And Chairperson, maybe I did not tabulate each one of those. I just summarized it as issues of governance, because for us, that's exactly where the problem is. To say, you have got a board who was established to assist the trustee in the management of this land. You have a board that is collecting the leases from business entities who are operating in the land. And yet, there is no clear policy of how that benefit accrues to that community. So if a chief wants a tractor or whatever, is that covered for in the policy? The improvement of a hall, is it what is regarded as part? So without those clear policies, in our view, we will be going back and forth. And that's why we are insisting that the new board must have those policies very clear and transparent, so that even yourselves, Chairperson, as the portfolio committee, you can actually know exactly how those benefits accrue to the different communities. And I think this issue of the holdings, this again, it's one of the issues to say, given what the legislation provides for in terms of the board in assisting the trustees, the subsidiary, is it the subsidiary of the trust? And I think those are the questions that have not been clear to us, which, as I said, honorable members, we're still engaging with the board because we want to understand who owns the holdings. Is it the trustee? Is it the trust? Is it the board? And because unless we clarify those matters, this issue that the Auditor General is raising will keep on coming back and forth. Chairperson, you are raising, and it's an issue that was also raised by Honorable Brett and Honorable Masipa. How do we locate the issue of Ingonyama Trust in the broader reform of communal land tenurial system? I must say, Chairperson, that from where we sit, that legislation ought to cover Ingonyama Trust land, because one of the issues that that legislation and policy as deliberated in the summit seeks to transfer ownership of the land of communities to themselves and their administration. I must say, Chair, that the issue raised by Honorable Masipa is Ingonyama Trust land, state land. As I've indicated when I gave the history, the title actually vests on the trustee. So actually that's the property of the trustee in custodianship of those communities. So in a sense, from where I sit, by the legal gurus who may advise, it's actually private land. And I think that's part of the dynamic with respect to how this land was alienated and put under the trust. So it's not state land per se, because it was never put under the sphere of particular government. It was put in a trust governed by the Trust Act, and the trustee being the king of the Zulus in as a custodian of those communities. So how the board argues that it can't pay rates and taxes, Chairperson, I, not being a lawyer, I'm not sure how that matters can be ventilated by the court, but as I say, that land is under a trustee. It's not under government in terms of the state land. With regard to the bill and policy, okay, maybe before that, Honorable Masipa also raised, do we think that it would be good maybe if people in Msunduzi were to apply for individual title or not? I think that would be the choice of individuals. However, what we'll need to understand is within the Trust Act, how can individual communities make preference of ownership where such land is collectively under a trust? And I think that's the matter which I think our lawyers might need to advise us. And whether the proposed bill on communal land bill provides for individual ownership. In the deliberations that had been held both in consultations at provincial level and finally at the summit, what has been agreed to is that the outer boundaries of the community land must vest in the community. And in terms of individual households, those will be registered in the name of the household. The question, therefore, is, are those going to be regarded as separate title or deed of grant? I think those are the matters where in the deliberations, there was a view that communities must make their own preferences of how they would want to deal with those issues. But our bill will create a broader framework that allows flexibilities from communities to make their choice. The other matter that also emerged was in a household, in a rural area, do you register, a household under an individual or a family? As we know that in communities, ekaya kusekaya, it's not like because the brother is there and therefore it's his house. He might be staying there, but I also have an equal right because this is my home and it's our home in perpetuity. So those issues were issues that members in the summit felt that you can't actually alienate or vest that property under one person because it's collective ownership, even this homestead. The Honorable Brad raised the issue about the time frame on the appointment of the new board. As I've indicated, we have done all the necessary processes. We have received the letters from the Premier as well as Inkosushinga on behalf of the House, which affirms us that we can continue on the recommendations that we've made on the 4, but on the other 4 where the Premier must consult with the House and the chiefs as well as the King, the House have actually recommended 3 names that they would like to be considered. And I think the Premier will finalize that. Our view is that we have to finalize everything by the mid of January, because that's the only thing that is remaining. Otherwise, we'll proceed. With the issues of legislative amendment, as I've said that we are waiting for the state law advisors pre-certification, we will then take to the first cabinet committee if we get that pre-certification in the beginning of 2023. And hopefully we will be able, as this portfolio committee, engage with the legislation in 2023. Honorable Matthias is correct to say, given the concerns that are being raised by communities, we need to find a way in which we provide improved tenure security for women and children, as well as households that are headed by children and other vulnerable groups, so that they are not actually finding themselves in a situation where they feel they are not protected in terms of inheritance and so on of such land. And again, this is what the bill is providing for in terms of the draft that we are working on. Nkosi Mandela, you are asking us, what are we proposing in terms of the legal framework to Cabinet? Having looked at the legal advice, we actually would like to propose to Cabinet that there must be an amendment of the current legislation of the board so that it provides clearly the status of the trust vis-a-vis the status of the board, as well as the relationship thereof. Thank you very much, Chair. On my side, I will ask through you that members of the board, or the other matter rather, which was raised by Honorable Mtwedi. Let me just indicate that Honorable Mngwengwe was not removed by anybody. Honorable Mngwengwe exercised his right when there was a vacancy in the Ingonyama Trust of a CEO, and he applied duly and he was appointed as a CEO. So he was not removed either by the board nor the ministry. We have actually, as part of supporting that board, seconded a financial person who have been assisting that board as part of the commitment that we had made in this portfolio committee. I would ask through you, Chair, that the members of the board and the CEO also respond to some of the matters that have been raised. Thank you.
Thank you, Minister, and thank you, Chairperson. Allow me to just deal with this thing of Ingonyama Holdings. I realize the confusion that has accidentally been created. Ingonyama Holdings is a private company that was incorporated by the trust, Ingonyama Trust. Because Ingonyama Trust operates through the board, it was by way of a board resolution that Ingonyama Holdings was incorporated as an entity of the trust being the only shareholder. Since the trust acts through the board, the directors of that company were appointed by a board through a board resolution, which therefore means if the directors were to be removed, they would have to be removed by the board through a resolution. With respect to where the finances of the trust are located, the revenue that comes to the trust through in the form of lease revenue or for any kind of other right that the trust may have issued through the board, that money sits in an account of trust, not anywhere else. When it is disbursed, it is also disbursed from an account of the trust. That is why in the annual financial statements of the trust, you will see a line on revenue that was received. You will see lines on expenditure that was incurred. Amongst what we would have expended money on would be disbursements to communities. So that is what it is. With respect to Ingonyama Holdings, at the present moment, because Ingonyama Holdings has been in a stage of being established, Ingonyama Trust made money available to Ingonyama Holdings as some kind of shareholder loans so as to get the company to be operational. So the issues that are being raised, that were being raised by the AG, for instance, related to the lack of terms of repayment between the trust and Ingonyama Holdings, but also it related to the lack of annual financial statements of Ingonyama Holdings, because the money that was transferred from the trust funds to the holdings then obviously had to be accounted for in terms of what it did. And if there are no annual financial statements, you would not have a sense, and that is what the AG was flagging. So I'm hoping that I've clarified the issue. There was a question by Honorable Basipa about what interventions the minister has made to ensure that people that took the IT to court get reimbursed. The answer to that is that because of the litigation having not been finalized, it is impossible of any party in the litigation to start complying with a court order that is being appealed against. What has happened, as the minister was explaining, is that in June 2021, judgment was released. It ordered, amongst other things, reimbursement. Then subsequent to that, the trust, because the parties in the court papers are the trust and the board, both the trust and the board appealed. Of course, the trust is acting through the board. Appealed against the judgment. Leave to appeal was granted by the High Court, except on the recusal ground, as Minister explained. What unfortunately, Minister, we may not have clearly provided that information to the Minister, is that even the issue of the challenge based on the recusal ground has now been finalized by the Constitutional Court. It was finalized on the 17th of November, actually this month. The Constitutional Court has rejected the ground of appeal on the question of the judges having had to recuse themselves. So what is left now is that the matter must be argued in the Supreme Court of Appeal on merits, on whether or not judges should have reached a different conclusion than the conclusion that they reached. So that process is still awaited, and depending on what the outcome is, if at the end the Supreme Court of Appeal rejects the judgment, it rejects the appeal. Let's say the trust appeals to the Constitutional Court. The Constitutional Court rejects that appeal. In the final analysis, the board or the trust will have to comply with whatever final order comes out of that. If the final order is the judgment of the High Court in KwaZulu-Natal stands, definitely there will be reimbursements of people, because that is what would have been ordered. The only reason why those things have not happened is because litigation is still not finalized. That is all there is to the issue of reimbursement. I think I've clarified this issue of who owns the holding. The Ingonyama Holdings is owned by Ingonyama Trust. Ingonyama Trust is the only shareholder, and that is all there is to it. I think that is all, Chairperson, that I wanted to clarify. Thank you.
Chairperson, could I come in with your permission on the question of an important principle of accountability, if I may?
Please go ahead.
Thank you very much, sir. For the record, and for all the honorable members and all the officials present, the trust is a creature of statute. It was created through an act of Parliament. Therefore, whether it is PFMA or not PFMA, the trust is accountable to this oversight committee. The trust is accountable to the beneficiaries, that is the traditional councils. If, for instance, they want information, it is very important for me as an individual on this interim board that we are accountable right up to the 10 Rand that is in our kitty. It is a principle that needs to be respected, and where maybe some statements have been made with respect, this board is accountable just because trust funds are trust funds, and we are a creature of statute. Thank you very much, Chairperson.
Chairperson, through you, I'm not sure whether there's still anybody from the board. We will take it back to you, sir.
Thank you, Honorable Minister, and the officials of the department and members of Ingonyama Trust Board. Honorable members, there are the responses. Any follow-up questions? Any hands? I don't see hands, honorable members. Any takers for follow-up questions? If not, let's thank the Honorable Minister, but I think one of the issues that we would want to follow up on is the cost of these litigations. On our side, we would want to follow up on and have them looked at. But I also would want to put it to the Honorable Minister in a broader context of the work of Ingonyama Trust. That being, it is not the sole monarch in South Africa. We do have a number of other monarchs in the country. And I've constantly asked the question whether if Ingonyama Trust has been a success over the 27 years, is there a need to grow it further to the other monarchs? Because it can't be that a department uses funds out of its coffers, 28 million rand to support one monarch in terms of a trust. If this trust is indeed a success story, when is the minister intending to roll it out to other monarchs? I'm certain that His Majesty King Rabulana in Venda would be awaiting to see such a trust being rolled out to the vendors. And I'm certain our young Reign Queen Mojaji would be looking forward to seeing this trust being rolled out for the benefit of their people. And so as many other kings and queens of our country. So in the minister's best understanding of this trust, what is the envisioned time frame of rolling out to other monarchs if this is indeed a success story? But if the minister is hesitating and feeling, hey, we got ourselves into muddy waters here, when are we most likely to rescind this act and have it closed if it is a nightmare for the department? That would be what I would want to ascertain, Honorable Minister, because it can't be that as a department we are seen to be skewed to one monarch. And I see the hand of Honorable Ntate Masipa coming up. Is there a follow-up question, Honorable Ntate Masipa?
Yes, Honorable Chair.
Please go ahead.
Thank you, Chair, and thanks to the Minister and the ITB for answering our questions. Chair, the point that just came to mind is when you were discussing, when you were making your remarks just now. And normally when we in this meeting and obviously engaged with the ITB, the chair the chair of the ITB always tried to remind the committee that this portfolio or the government is responsible for only, call it a third of the contribution towards the ITB. And therefore our oversight should be limited to that particular amount. I think it's about 22 million or billion. I can't remember exactly the exact amount. Million. And the rest of the amount is coming from obviously the collection of the levies and the leases. So I just really want maybe the minister to just advise in that regard as to really where is the committee, what is, whether the committee has got in its right to actually call it oversight on the total usage of funds that are being collected, because that's our understanding, that we have to do oversight on the total funds that are being collected from obviously the residents under the ITB. Thank you, Chair.
Thank you, Honorable Ntate Masipa. You can lower your hand. The Ingonyama Trust Board and other entities with its names such as Ingonyama Trust and Ingonyama Holding are a result of the Act, are a result of Ingonyama Trust Board's existence. And therefore, we exercise our mandate in holding it accountable for its work in its entirety. This is what our mandate is, Honorable Minister, and I would hope that the department even itself, it is consuming its time in worry of its entity on the entire mandate and the work it does, but not on a subsection of its work. But let's head over to the Honorable Minister to take us into confidence on these matters.
I can't say the chief is naughty. That is appropriate. But Nabezita and members, I think the issue that is raised by Honorable Masipa, and as you have reflected on it, the board member, Advocate Linda Zama, I think has articulated properly that this is a creation of statute, and therefore accountability to the last cent of whether that resource is within the trust or is within the board must be accounted for. And I think from where she sits is correct. And this is one of the issues, Chairperson, that we've raised, which has really been a matter toing and froing between ourselves and the Chairperson, and the understanding of what accountability should be about. Whether those resources are levied, whether they come out of the lease agreement, the interest of the minister as well as the oversight by the committee is to see whether those are actually used for the benefit and interest of the trust and the communities concerned. So I think that answers Honorable Masipa that your oversight as the committee should be holistic. On the cost of litigation, Chairperson, we will indeed ask the board on the cost of litigation since the start of this matter, which in part was the reason, as the minister's view was, we should not proceed with the appeal, but as a juristic person, the board felt it needed to ventilate some of the matters arising out of the judgment in the courts. Chairperson, you ask a very challenging question in respect of what is one's view with respect to rolling out the board, if it's doing correctly, I mean, the trusts in the other areas where you have got monarchs. I wouldn't actually say one, maybe let me say, Chairperson, the difficulty in the question you're asking is because if one looks at the origin of this trust, it was actually as a result of a decision of the then KwaZulu government, not necessarily by the monarch. But in its wisdom, the KwaZulu government then felt that the land under that territory will be best protected under the monarch. So this creation of this trust did not necessarily emanate from the monarch in one way or the other. However, the question that you are raising, which is correct, is that in terms of the legislation, even its original legislation and its amendment thereof in 1997, it then says the state, through the Department of Land Affairs, will then give support to the board. And I think this is where the contention which you are raising correctly, Chairperson, to say, can we, in the instance of a republic, have one treatment of land under one monarch treated differently and supported by the state, whereas in the other, there is no such vehicle? And I would actually say, Chair, for me, these are the matters that we will have to reflect upon, including this committee, in your wisdom, in the assessment of this trust, whether we really think we should roll out a similar structure, and whether or not, given that under different communities, you might have monarchs, in other communities, you may not necessarily have a monarch, but you'll have different traditional authorities, and therefore, how would you deal with it in this instance? Would you confine it to those areas where you have got a clearly delineated monarch, or will you do it across? And I think those are the matters, Chair, we will have to collectively, with all the wisdom of people in this committee, deliberate on. I will be lying if I can say I will have an individual view presently as the minister and the department in this regard. Thank you very much, Chairperson. I've not made you none the wiser, but I've really said it's a matter that requires better assessment, because I think your own experience as this committee and the committees before you might then come to a better and, a recommendation to say, with this experience, do we think such should continue, or amendment, or even rescinded, which therefore might mean a repeal of the legislation. And the question is, will the repeal of the legislation that provides for Ingonyama Trust Board mean you are dismantling the trust, or the trust can still remain in terms of the Trust Act with the assets that it has? I think those are some of the issues we will have maybe to look at legally and say what is possible and what is not. Thank you very much, Chairperson.
Thank you, Honorable Minister. I would put it to you, Mpati, so that with returning 1.1 billion rands back to the coffers of Treasury, you will find that whether it be 22 million or 28 million given to the ITB can go a long way in support of all other monarchs right across the landscape of our country. And it is a topic and a subject that we need to consume ourselves with and ensure that we deliberate on this matter, or else we stand to be seen as a department and a community that is simply having an interest of one sole monarch in the country. We are not an absolute monarchy, but we are a constitutional democracy, and we pride ourselves in the diversity of our nation. And that nation's beauty lies in the nations within it. And I think there can be greater deliberations in ensuring that all our kingdoms and our monarchs are supported equally and are given an opportunity to administer and see to their communities as best as they are most capable of doing so. Honorable members, on that note, we will wrap the proceedings in terms of Ingonyama Trust Board and Ingonyama Trust with included Ingonyama Holdings. We had also requested the minister to speak in terms of the special master report. So we will then afford the minister to respond on the issues centered in and around the special master. Honorable Minister.
Thank you very much, Chairperson and honorable members. Just to say, Chairperson, I'm happy that you are here to assist that we deal with the other matter that you have just concluded on, because indeed it may arise as to when you transfer the land to this community, what becomes the role of the state in supporting those communities with regards to land administration and development of their areas. Chairperson, you've asked us to come to you to indicate matters that relate to the decision of the court in the establishment of the special master. As an officer of the court and what was defined as the role of the special master in order to ensure that there is a speeded up process on the finalization of the labor tenants claim. Our understanding of the mandate of the special master on labor tenants as per the court decision is that the role of the special master should supervise and monitor performance of the Director General and the department regarding the functions of the department as they relate to the resolution of outstanding tenants claim in terms of section 16, 17, and 18 of the Labor Tenants Act. Among those issues that were also highlighted was that the special master will have to satisfy himself or herself on the financial allocation on a yearly basis to ensure that the execution of the settlement of the labor tenants is undertaken. And therefore, the special master remains an agent of the court. Special master reports to the court and acts in extension of the court's own supervisory jurisdiction. The appointment and the way in which it was done, it actually was done by the court and requesting proposals from those who had filed the court and others on the recommendation of such an individual, which was duly done. And the role of the department would be to support the work of the special master so that the special master execute the decision of the court.
Apologies, Mpatiso. Apologies. I see Ralph is sleeping on the job now. I thought he would catch up with you and flight the presentation. Ralph, you are always on point, but I see you are, okay, please enlarge the slide. I think the minister is already on page 2. Yes, you may proceed, Honorable Minister.
Thank you very much, Chairperson. If one were to look at the elements of the plan in terms of what the court decided, on October 29, 2019, the court ordered that once the special master is appointed, shall prepare in collaboration with the Director General or delegate to deliver by no later than 31st March 2022, a plan for the performance of the DG and the department with supervision by the special master in relation to pending labor tenants claim under section 16, 17, and 18 of the Labor Tenants Act. And the plan must set forth the following: that the total number of claims lodged to date and the number which have not yet been processed and finalized, an assessment of the skills pool and other infrastructure required for processing labor tenants' claim, and to what extent such skills pool and infrastructure is available within the department, and the targets on a year-to-year basis for the resolution of pending claims, either by the agreement or by referring the claims to court, a determination of the budget necessary during each financial year for carrying out the implementation plan, including both the department's operating costs for processing claims and the amounts required to fund awards made pursuant to applications in terms of Section 16 and the Act. The plan must also ensure that plans for coordination with the court to ensure the rapid adjudication or arbitration of unresolved claims referred to it in terms of Section 18, subsection 7, read with Section 19 to 25 of the Act, and that any other matters which the special master may consider relevant. I must say, Chairperson, that after this process was done, the special master felt it was necessary for him to visit the various provinces where majority of labor tenants were located, and subsequently had a discussion with the labor tenants to outline how he was going to execute his task as a special master. And I would like Bonkosi to actually indicate to us through presentation as accepted by you, Chair, to then take us through the process. Following from there, how has the process flow of the implementation plan been undertaken to this end? I must also indicate, Chairperson, that there is a particular approach that the special master had actually indicated he would like to use as part of his support and oversight, even though it might seem it veers into implementation, but in his view, he felt it was necessary as part of ensuring that such a process is undertaken fairly. I will now ask Bonkosi Zulu, through you, Chair, to take us through from here in terms of the implementation strategy onwards.
Thank you very much, Minister. Thank you very much, Honorable Chairperson and the members. I'm going to take the committee through from here, from this slide. As Minister has indicated, the special master then, in terms of the implementation plan, he came up with 10 key areas that he wanted to focus. However, what was important is number 6, where the approach was to deal with these labor tenant claims in a programmatic fashion, what he called a multi-site accelerated claims resolution initiative, which was then adopted and presented in court, workshopped to communities that are affected and those who are representing the labor tenants, which means that there were different steps that the special master proposed in terms of the resolution of these claims, one of which was to look at the research and also look at the historical research on the issues of settlement of the labor tenants, because during the assessment, it was discovered that some of the labor tenants were removed from where they initially resided, and then we had to consider the historical evidence, which of course we had to, through working with the special master, appoint experts to do those kind of historic research on some of these claims. As Minister have indicated, I will also talk to the figures in terms of what was outstanding, precisely in line with the court order, that out of all the sections in the Labor Tenants Act, as Minister has indicated, the court order did not take away the powers of the minister and the delegations of the DG in terms of the act, around the implementation of the act. However, the special master was to oversee the already lodged claims in terms of section 16, and make sure that
We seem to have lost you. Are you still there? Hello, are you still there?
Yes, I'm still there. Honorable Chairperson, I was saying, I think there is a connection problem.
Honorable members, can you follow? Are you following?
Chairperson, there was a part that I missed. I think the presenter broke up.
Okay, can you hear him now?
Yes, I can hear him now, Chair. Thanks.
All right, please proceed.
The next slide. I've already spoken to this approach by the special master, which precisely one of the capital areas of the multi-site accelerated claims resolution initiative. The presentation has just got lost.
It's been uploaded again. There it is. You may proceed.
Okay. As I've said, part of what the special master was supposed to do was to confirm the outstanding claims, as the minister have alluded to, which were lodged in terms of section 16 by December 2001 by the labor tenants. Those were the numbers as you can see them. We still have to be finalized. Out of the 20,325, 9,383 at the time when the order was granted, they were outstanding. Then the targets that was agreed upon in the implementation plan was the targets that can be seen on the right hand side, which forms part of the implementation plan that was presented to court. On the skills, also, as Minister has alluded to, the special master had to undergo a process of conducting a detailed skills assessment within the department on the officials that are tasked with this project, and that to identify the gaps and make recommendations to the department. And in terms of the budget, to confirm the budget, which was confirmed. However, I will also talk to the issue of the budget, how the budget is allocated to this particular program of land tenure. And also that in terms of coordination, the special master together with the department should on a quarterly basis report to court, which we have been doing constantly as advised by the court. This is basically the summary of what the minister have presented in terms of the work that was supposed to be done by the special master working with the department and the AFRA, who is representing the persons that took the department to court. Next slide. In terms of these figures, we have broken it down to provinces. I have highlighted the province of Limpopo because initially, after the assessment, we discovered that there were 294 that were lodged in the province of Limpopo, vis-a-vis the 100 and something that was in the initial documentation, which that has now increased the total number of outstanding labor tenant claims to be finalized, which was then the target that was in the application. In the implementation plan to court, and then as I've alluded to on the right hand side, that accelerated claims resolution initiative, which was developed, and with its element which are presented in the slides before. Next. Now, the special master together with the department went through all these category of claims that were outstanding to look at the various categories of these labor tenant claims, because they were not the same. As we look at them, we're looking at the applications, the section 16s, in our assessment of all of them that are outstanding. We discovered that there are about 10 categories of these particular claims in the outstanding claims, and some of them we discovered that they are untraceable, and the applications that we received in terms of section 16, we also discovered some of them they've got no dates, or they were not signed off, or the names of the properties that were written in these particular applications were not the registered property descriptions of the properties, and they were just using common names, like they know them. And some of these applications, because the department was not the one who was leading the campaign for the labor tenant claims, they contracted external service providers, AFRA and Transvaal Action Plan company that was doing the campaigns, especially in Mpumalanga, KZN, it was AFRA. They collected the information. However, we discovered that there was no standard in terms of the act. You will see in the presentation, I've also attached the sample of a section 16 notice, which when we looked at all the applications that were received, they were not compliant with that, and there were other issues where we couldn't find the location or the addresses of the applicants. However, we went through a process also in KZN and Mpumalanga of going to the media and all other platforms to try and trace the labor tenants that we couldn't find in the application forms, although the application form, we have the application form. However, in some instances, as we implement the program, we discover there is a category of labor tenants who have applied. However, they don't have the reference numbers or proof that they have applied, but the circumstances under which they live, they qualify to be labor tenants. We have also, Honorable Chairperson and members, put a slide in the previous slides where the act, how do we define a labor tenant? I think that was important for the committee, because in terms of the definition, the labor tenant is clearly defined whether you have lodged a labor tenant, a section 16 notice or not, but you remain a labor tenant. For the section 16 notice is where you ask in government to award land to secure your tenure rights on a particular property or particular piece of land. That is what currently we are processing. However, what we also discovered is that in the event we are settling labor tenants, there is a big farm, but there are other persons which we define as farm occupiers, which by definition, they qualify as labor tenants. However, they've never lodged the section 16 with the department by December 2001. So we then, in the final analysis and the settlement of that one labor tenant claim or two labor tenant claimants in a particular piece of land, we therefore consider all the persons or community households that are residing in that particular piece of land without any discrimination, because by definition, they are labor tenants, even though they have not lodged a section 16 notice. Next. The next slide indicates how the progress in terms of the assessment, which was done by the special master. However, the if you look at how the department was structured, especially the tenure reform, the officials that are in provinces and districts, they are not necessarily, or they were not necessarily working only on labor tenants. They are working on tenure reform programs across the board, all the 9 pieces of legislation in each province or each district, which made it very difficult for the skills assessment process. However, that was done and concluded, and it came out with the recommendations. As you can see, the areas that were identified in terms of the assessment as required by the court. That report also was presented to court to comply with what the special master and the department was expected to do in terms of the implementation of the plan that was submitted to court. Next. In terms of the capacity that exists, however, as I've mentioned, these particular individuals or officials of the department in each province, they are not necessarily the manner in which, the way in which the structure of the department is, or of this particular unit responsible for this. They are not only responsible for the labor tenants only. However, these are the persons that were assessed by the special master who already exist. However, the special master's report in their assessment also noticed the fact that these particular officials are not only focusing on the implementation of labor tenants, which makes it difficult, as you will see the progress on this particular matter and how we're trying to beef up the capacity on this. However, the 149 that are filled are still responsible for other programs. However, the department undergone a process of procuring contract positions, officials that were on contract, which were only going to focus on the implementation of the labor tenants implementation plan as presented to court, working together with the special master, which is obviously was not sufficient. You will see the targets that are still outstanding in terms of the claims that still to be finalized. And we also went through a process of the fit for purpose in the department, where we have catered for this particular need, this capacity requirements for the implementation of this particular program. Next. This is just a summary of what we have done to beef up the capacity. Mpumalanga and KZN are the provinces with the majority, as the committee have noticed in the previous slides on the numbers, the breakdown per province, with the highest number of labor tenants. To beef up the current capacity, we have concluded the 18 contract posts for Mpumalanga, which seems to have the largest number, and the KZN had managed to convert all their contract posts in the previous 2 years, and they were left with 7, which have now been advertised and filled to beef up the capacity. And these particular officials in these 2 provinces, they are going to focus mainly on the implementation of the labor tenants, and not other programs as initially alluded to. However, the other officials that are also implementing labor tenants will also supplement this capacity. The biggest problem that we had was that we couldn't increase the capacity on the current organizational structure of the department. However, the only possibility that were given by our human resource and DPSA was to appoint this person on a contract basis until we finalize the fit for purpose structure of the department, which we have catered for in that particular structure, which I hope once finalized, the committee will be appraised. Now, on the performance, since the appointment of the special master, it has not been a good performance that we have acknowledged. The settlement of these outstanding over 9,000 claims has been very slow. And the committee will remember during the oversight, those were some of the issues that we grappled with in terms of the of finalizing the outstanding labor tenant claims. A total of only 304 since the appointment of the special master, who started in 2020-21 financial year. To date, that's what we have. That is what has been finalized, which is the needs more improvement. Is something that we have noted. And we're working with the special master to try and improve on this particular performance, which is not acceptable. We also agree as the department. On the budget allocation, the important part on the budget allocation, Honorable Chair, you will see on the next slides is that the budget that you saw, which was part of the implementation plan, is not separated between your ESDA, in other words, acquisition of land in terms of Section 4 of the Extension of Security Tenure Act, which covers any other persons whose security of tenure is legally insecure in terms of Section 25(6). We use the same budget in terms of the allocation from National Treasury. They've not separated the budget for labor tenants and the ESDA occupiers or any other labor tenants or any other farm occupiers. We are given one vote, one amount of money, which we use to implement or settle or finalize the labor tenants as well. The other issue on the assessment, as I've alluded to in terms of Section 18, which I've mentioned in the previous slides, as ordered by the court for the special master to oversee on the settlement of these outstanding labor tenant claims. There are two options that we have. One is negotiated settlement, where we acquire the property and transfer to the labor tenants or the farm dwellers or those communities who have lodged applications. Or if there is a dispute, we have to, through the DG, the Director General, refer those matters to court in terms of Section 18 of the Labor Tenants Act. To date, we have finalized that, and we have a lot of cases that are pending in court, which are approximately about 450 of them. Those cases we are in court, especially from Mpumalanga and KZN. The biggest problem on this particular, we are not seeing a movement for a number of reasons. One of them being the fact that there is a serious capacity problem within the Office of the State Attorney. Because in terms of the Labor Tenants Act, the DG, when he approves the case that must be referred to court, that matter have to go through the Office of the State Attorney, who will then refer the matter to court on behalf of the department. That's how the act is. Even if we can appoint a private lawyer, but that private lawyer will have to work through the Office of the State Attorney. Especially in KZN and Mpumalanga, where we have a majority of these cases, they are not at all moving. We engage with the State Attorney's offices on a number of bases, on a weekly basis, our legal officers in these two provinces, to try and fast track these cases. However, the resolution of these cases, which impact on the finalization of these claims, because the landowners, they are disputing the labor tenants as labor tenants. The only option we have is to take the matter to court for a determination. Next slide. We're just reflecting on the targets that we had and what we have delivered to date, and the applications that have been finalized since the the order was granted and the appointment of the special master, which, as I've indicated, is not a good performance. We are working on that with the special master. Next. In terms of the compliance, which we have agreed on the compliance register with the special master on what the ordered the special master and the department to do across the 10 items that the minister alluded to, which was part of the court order. We have finalized most of the matters. However, what is still a problem after we've done all what the 10 attended to the 10 issues that were in the court order, the speed at which we finalize the actual cases, the claims that are outstanding in terms of section 16 and section 17 of the act, then that one, it becomes very low. I think the minister has alluded to the fact that maybe the approach that was adopted by the special master with all these other things that need to be done prior to the settlement of a labor tenant claim, the one way or other causing some of the delays. However, the intention was to make sure that we get all these cases, we have the information of all the outstanding cases or claims for the labor tenants, and the referrals to court, we were in progress with those, as I've indicated. However, we've got serious capacity constraints within the office of the state attorney, who is supposed to then, after the DG approval, take those matters to court for a declaration. We have attended to most of these matters that are listed in the court order as indicated by the minister. However, we are just struggling in the actual finalization. The budget has been allocated. You'll see in the next slide, the operational budget, to make sure that the office of the special master is functional. The budget has been dedicated and allocated directly to the office of the special master for their operational cost. And the budget, obviously, as I've indicated, for capital budget, I'll indicate on the next slide. Next slide. This is the operational budget, as I've mentioned. After the order, this is what the department has allocated for operational purposes for the office of the special master to run as an office and do what they're expected to do in terms of the order. And as guided by the court order, that the department must support the office of special master with a budget dedicated to the office of the special master for operational cost. This is the expenditure. This is how much we've allocated in 2022-23. In terms of expenditure, the special master has administration persons appointed as per the court order, who are working in the office of the special master to support the special master in its operation to oversee the work of the department. In terms of the expenditure, I will hope that if there are issues that the committee will want more detail on the expenditure from the office of the special master, that can be provided and explained through the office of the special master. The next, this is the capital budget as allocated. As I've mentioned, Honorable Chair and the members, one of the issues
we seem to have lost our presenter. Are you still there?
But the cost drivers in this budget that
you're breaking up. We don't seem to hear you. Are you still there, Bonkosi?
He might be having the challenge, Chairperson, but it was towards the end of the presentation, which really dealt with the financial allocation for the program specifically, as well as where the expenditures are. And I think the last slide was really thank you.
Thank you very much, and my apologies, Honorable Chairperson and the members, and thank you, Minister. Yes, indeed, this was the last slide on the budget expenditure. I was just explaining that in terms of the allocation, with the understanding from the committee that they want the separation, it's something that we will work on. However, currently, in terms of the financial system, we are allocated the budget for tenure, and that budget, the key cost drivers is labor tenants when we acquire land for them. And also the other key cost driver is the on ESTA when we acquire land in terms of Section 4 for labor tenants who have not lodged the Section 16 notices, who we declare them as farm occupiers. However, this is how the allocation is currently from the National Treasury to the department. Thank you very much. That was indeed the last slide. Thank you, Chairperson.
Chairperson, thank you very much. I think that's the presentation. We can take it back to you.
Thank you, Honorable Minister, and to our presenter official of the department. Honorable members, there is the presentation of the Department of Agriculture, Land Reform and Rural Development on their state with the special master. We'll now open the session for questions of clarity, if any, or comments. Honorable Kabe. Any questions on your side, Honorable Kabe? We move on. Honorable Mbabama, still not on the platform. Honorable Ntate Masipa, may proceed.
Chair, I think Honorable Masipa has lost signal.
All right, the Honorable Ntate Matias. The Honorable Ntate Matias. Tim Velas Bautapa. The Honorable. You may proceed. No questions on your side.
No question.
Of course. The Honorable Kruger.
Thank you, Chair. Chair, we all know that the Department of Rural Development and there's a lot of unqualified officials. And that's the one thing which I want to know, what is the minister going to do about it? And the second one, there was a court order to create a budget for to deal with matters related to labor tenants. So I just want to find out how far are we with this, because it seems like the senior officials that's not qualified are struggling to get this, to put this budget and this whole program together. Thank you, Chair.
Thank you, Honorable Kruger. The Honorable Memasho.
Honorable Chairperson, I don't see, but there is just one thing that one would like to understand. I think maybe I missed it when they were doing presentation with regard to the issue of development on the land that is given to labor tenants. What are the bottlenecks for them not to get development or support? Because in the recent oversight visit that we did, we have realized that the issue of development for labor tenants, for farm workers or labor tenants, they are not being supported as much. So I was just asking that one question. Maybe I missed it, forgive me, Chairperson, but that is the only thing for now. I don't have many questions, Chair. Thank you.
Thank you, Honorable Memasho. Agbare Breed.
Dankie, Voorsitter. Chairperson, I just have 3 questions. The first one, maybe let me start with, they were speaking of the fit for purpose structure that is in the process of being approved, and then they will be able to make the appointments. I just want to know, when do we foresee the approval of this fit for purpose structure, and when then do we foresee that these positions can be filled and we can actually get going in terms of these labor tenants claims and settling these outstanding claims? I think that's very important. Then, Chairperson, on one of the first slides, there was the true reflection of what is outstanding, and that was 9,333 outstanding claims. And then if you look at it was on the right-hand side of that slide, they had the projected, or what they submitted to court in terms of outstanding claims, and that was for the year 22-23, it was 2,000, and then for 23-24, it was 2,500, which brings that total to 4,500. So there's a disparity between the 9,300 and the 4,500. How are we going to reconcile that? Because I'm seeing as well, when we speak to the budget, that we're only planning and we're only budgeting to the 23-24 season, or financial year rather. But that still then leaves, so much outstanding claims. My fear is that we've got so many outstanding claims. We've budgeted for 4,500 in the next 2 years. That means we still have half of those true outstanding ones that will be outstanding. So how are we going to reconcile that? What is our plan of action to ensure that we stay within that timeline? And I think it was Honorable Kruger that asked, what is the timeline of the court order? I think that's very important, specifically taking into account that the department is not following the settling the outstanding claims as was proposed. And then lastly, Chairperson, which also speaks to that outstanding settlements, is if you look at the allocation and the expenditure, we are year on year decreasing both the allocation and the expenditure of that. I think the last slide made mention that in total, it will only be a 29% expenditure of the allocated budget, with the 23-24 year being 4%. Spending actually of that budget. How is that? How are we getting to that amount? Because it doesn't. My fear is we have this number that we are chasing in outstanding settlements. We have a decreasing budget. We are ending our year in terms of the court order, in terms of our allocation to do that. And none of these things are actually adding up, and we will come to the deadline and then actually see there's no budget left, still outstanding settlements left. And once again, we will see our labor tenants and our people, the most vulnerable, being failed. So if the department can just speak to that, Chairperson, I hope it makes sense. Just that was my train of thought, Chair. And let me leave it at that. Thanks.
Dankie, agbare Breed. Ndabezitha, Kosenkulu, Honorable Cebekulu.
Thank you, Chairperson. I don't have a question or a comment. Thank you.
Honorable Montwedi.
Ke a leboga modulasetilo madume gape go wena minister le botlhe ba ba mo kopang. Chair, in your opening remarks, you did make mention of the fact that the budget of the department, after that, the budget of the, I'm really sorry, Chair, that the budget of the department should actually be compliant in terms of what the court order said, stating that there must be a determination of the budget necessary during each financial year for carrying one, the implementation plan, and the department's operating cost and funding in terms of Section 16 of the Labor Tenants Act. Now, I want to check, Chair, to say the department, can they show us a budget that indicates those three things? I think I've already mentioned what are they. Number one is the implementation cost. Two, the department's operation cost, and the funding awards that are actually made in terms of the Section 16 of the Labor Tenants Act. That is the first issue, Chair. Now, I also want to check from the side of the department, Chair, to say, since the appointment of the special master, it dealing with these issues of the labor tenants, how have we seen the finalization of the Labor Tenants Act? Because I remember at some point in the department when they were giving a report to us, they indicated the challenges with regard to the Department of Justice as one of the reasons why they are unable to finalize all of these things. I want to check from the side of the department, Chair, how has it been? Is there any progress towards a resolution in terms as we had actually anticipated matters to be resolved, Chair?
Thank you, Honorable Montwedi. Any other honorable member on the platform who have not been able to recognize? If not, honorable members, will hand back to the honorable minister and the department for responses. Patricia.
Thank you very much. Can I ask the officials to start and then I'll come afterwards, Chair?
Thank you.
Thank you very much, Honorable Chair and honorable members of the Portfolio Committee.
Good afternoon, DG.
Good afternoon. May I ask that Zulu to start, and then I'll follow up.
Makeba.
Thank you, Honorable Chairperson, and thanks to the Minister and to the honorable members. On the issue, I think on the issue of I think Honorable Kruger, I think Minister will and DG will deal with that. And on Honorable Marshall, on the issue of development, I think also DG will deal with that. However, in the department, we've got a branch that deals with post-segment support. We've got a land development support policy, which is one of our sister branches that deals with that, which we are in discussion with them. I think DG will talk on that particular one. Honorable Briet, I have explained on the issue of targets. The implementation plan speak about 9,333 outstanding. However, I said when we did the assessment, because of the overlapping boundaries, you remember in the Limpopo, the Skukune, parts of Skukune were in Mpumalanga. When we did the assessment and the verification, there were applications that fall within Limpopo, which increased the outstanding claims within the Limpopo province to 294. Then there was a slight increase in the 9,333 to 9,468. On the issue of the allocated budget, and expenditure in the slides, I have indicated that in terms of the MTEF allocation, that's the MTF allocation that the honorable member we have presented there over the 3 years. Obviously, when we do the next MTF, will cover the remaining the 5-year period, which is the term of office as per the court order for the special master. I think the minister has alluded to the court order that the special master is appointed for a period of 5 years, which of course those were the targets within the period, which it means that after the period, we'll still continue with the implementation of with the settlement of the labor tenants outstanding, as you can see it in the presentation, what is still outstanding. The issue on the budget allocation, yes, indeed, I have alluded to the fact that the expenditure, because of a number of reasons that I've put forward around the issues when we are settling these labor tenants, and the approach that was adopted when the special master came in, and the issues that we have discovered in the settlement of the remaining or outstanding claims, the over 9,000, then the expenditure and the delays in terms of the finalization of these matters in court, the cases that we refer to court in terms of Section 18 of the Act, because once that is done and the determination is done by the court, whether in the issue of a dispute of a price or the dispute in relation of the labor tenant claim itself, because most of the landowners, they are denying the status of these labor tenants. And once that is done, if they agree, there is still an issue of the price where the landowners, they reject the offers from the OVG. We have to take those matters to court in terms of the Act under Section 18. So those are the things that delay the expenditure as you see it, and which I've indicated is not a good performance in terms of that expenditure as well. And then, Honorable Honorable Mutweni, yes, indeed, the slides that I've presented, we have broken down the budget allocation into the operational, which I have alluded to, which is the money that we've set aside for operational cost for the Office of the Special Master, with all the support staff that is there and all the requirements or assets that they need in terms of the goods and services, the tools of trade. That operational budget I've indicated, and the expenditure on that particular budget is there in the slides. And then on the capital budget is the one that I was saying, yes, we have acknowledged, Honorable Chair and the Honorable Members, that there is an expectation that the budget must be separated, to have a separate budget for labor tenants and a separate budget for other tenure programs or for ESTA, for the Extension of Security of Tenure Act when we acquire land. However, currently, the manner in which the National Treasury and the system works, they have allocated us the budget under household with one vote, which is something that we are engaging our finance, obviously our CFO, to have a separation. And if it is done, how it can be done, because it has to be approved somewhere through the process of the National Treasury. The performance since the appointment, one of the issues that is raised by Honorable Motweni, yes, I have alluded to the performance, which I said in one of the slides is not a good performance, and we obviously not happy about the performance under these circumstances, which we are engaging with the Office of the Special Master on how we can improve on this performance. However, we also need to, we have also agreed on how we need to deal with the issue of the state attorney, because the capacity within the state attorney, unfortunately, the Department of Justice is the one that needs to be engaged to deal with that particular capacity within the state attorney, because the current act now, it forces the department or the DG to refer this matter through the Office of the State Attorney. Of course, the State Attorney needs to capacitate itself to make sure that this work is done. Currently, that is where we are having a problem. I'm hopeful that the Minister and the DG will attend to that particular matter that we have raised in the presentation. Let me stop there on the ones that I've noted. If I've missed some, the DG and the Minister will also help me. Thank you, Chairperson.
Thank you very much, Honorable Chair. Let me give attention to two issues that were highlighted here with a clear emphasis, Chair, that the Special Master, as we have come to understand the role that they have, is that they would be a problem solver and a solution finder with three very distinct functions that they have got to perform. It's to oversee the work that the department is doing, and they have got to monitor on the work that the department has been doing. And we hope that in terms of that, we arguably looking at the full implementation of this act of securing those who have claimed and whose claims have been upheld in the system. Now, two issues that were highlighted. I think Honorable Clear raises an issue to say that the department is staffed by unqualified people. I think that's basically stemming from the initial report that came from the Department of Public Service and Administration, and the work that is there. I would like to openly indicate that the department would share the qualifications of the individuals who are within the department, so that it can be known that the levels of qualifications that we have in the department, because while the aspect of there are some unqualified people, there are qualified individuals who are in positions in government who are doing this work around tenure reform that we are having. Where there is an aspect, it's the number of people that we have in this space who can assist us to deal with this work. And that is why ultimately what we have got to do is to fortify the space. Minister in her presentation earlier on had indicated that we're starting up with a directorate that will deal with communal tenure, but we're also working towards fortification, the general tenure in the system. The presentation referred to the fit for purpose structure, and I think we have presented at the portfolio committee highlighting the need for a fit for purpose structure in the department, so that we can be able to adequately respond to the mandate of the department, so that we can have a system that would be responsive to the needs on the ground. And we are doing that as a matter of agency. We expected that we would be able to do that by the 1st of April. If that fit for purpose is not yet up and running during that time, what we will do is that those aspects that are very urgent in terms of working will be fast-tracked, so that we can also implement while the processes may be delayed. I think that's the way that we would look at the issue of filling the vacancies within the tenure system. I think in our engagements with the Special Master, what we also became aware of is that in line with the human resources. Some of the posts that we have are actually manned by contractual workers that we contract in for a specific period of time. We want to change this so that we can have permanency in terms of labor tenants, but not only specifically for labor tenants, but the general tenure reform issues that we have got to deal with in the department, which is a broad-based engagement that Minister had articulated this morning as she gave the history of tenure security in South Africa. Those are the two issues that I had picked up from the notes that I had made from the honorable members who had articulated the work of our department. I think, Honorable Mtwedi, the issue around the budget, it's something that we internally have got to deal with, looking at the judgment itself and how we then have got to give the budget. But the budget, as indicated, will be around the three functions, because implementation is still the responsibility of the department. The issue that we are looking at is to ensure, because the special master has been given a task that as and when they look at the claims that have been lodged, they have got to look at the most sure route that would ensure that the relief that is being sought has got full implementation. And therefore, we are allowing some of the SOPs to route in, but the implementation remains with the department. And therefore, any amount that goes to the special master would be relating to the administration to look at the three functions that the special master has. Thank you very much, Honorable Chair.
Thank you very much, Honorable Chairperson, and thanks to the DG and Mr. Zulu for the responses. Thanks the members for the questions. I think the questions have all been answered to. Maybe just to reflect on an issue raised by Honorable Mahlo, that the issue of support to labor tenants, how can that be improved such that they also get supported in terms of their land needs. Indeed, we take note of that in the assessment of farmer support. We've really looked both at restitution cases, land reform or land redistribution programs, labor tenants and farm workers, that it is important for us as a department to put resources aside to support these individuals and communities, particularly working with the provincial departments of agriculture, so that through the programs that they render, they do not miss these beneficiaries of land reform from the different programs, acknowledging obviously that they may not have enough resources in their equitable share. The issue of financing, as it is indicated, I think the court was very clear, even though it did not put a quantum, but it was very clear that there should be proper and adequate financing for this program in order to ensure that we resolve the remaining claims. And that's what we've sought to do in terms of MTEF budget. And I think what we need to do going forward, Chairperson, is to clearly delineate how much in terms of tenure goes to the labor tenants, to the farm workers in terms of extension of security of tenure, and also other tenure-related matters, so that it's very clear from the committee when you do an assessment to see exactly the quantum that is for this specific work. On the issue of unqualified staff, the DG has responded to, and I must say that, Chairperson, you would appreciate the decision that has been taken by the 6th administration led by President Ramaphosa on the need of the professionalization of the civil service. And indeed, that's what we are aiming for, to make sure that those that are in our service are people who have the capability and the expertise to undertake their task. That's why it was necessary that when the special master start his task, worked with the department to actually look at the profile of the people that are there and how those people in terms of their competencies can actually be utilized within this program and the need for filling up the vacancies that are there so that this program is not compromised. Obviously, we'll have to look at a number of areas in terms of adequate placement of people within the department as part of the fit purpose structure in terms of their qualifications and where they are placed. As you know, Chairperson, that this department has gone through reconfiguration of a merger, which brought some functions and removed some functions. And therefore, in terms of this ongoing assessment of staff and their placement, it must be in accordance with the function, but also with the expertise that they have. Thank you very much, Chairperson. Back to you, Ndabezitha.
Siyabulela Mphathiswa and the officials of the department, the DG Ntate Ramasodi, as well as Umageba Ubauzulu for the responses. Honorable members, any follow-ups on the presentation on the special master? Yes, Ma'am.
Yes, my follow-up question to the department and the minister is that I didn't hear or I didn't get it with regard to the issue here. They're working together with other departments, like when they've given the farm dwellers a land where you find that these people, they don't have water, where there is no clinic, where there is no any other developments. But I just wanted to check as to whether their intergovernmental communication, I didn't hear it clearly. I didn't get it clearly when they were outlining it. How are they going to work together? Because if one department, like Department of Agriculture, is going to give these people a land, at the end of the day, they don't have water, they don't have sanitation, they don't have this and that. How are they going to address that? Maybe if they can just clarify me on that, I will be in a better position. Thank you.
Thank you, Honorable Memasho. Any other follow-up question, honorable members? If not, honorable members, I would want to dwell further on the issues that have been put before the committee. Because for me, I am still unclear, Honorable Minister, in regards to the special master when it comes to the budget. And maybe you can clarify this, because does it mean this that the capital budget as things stands is still non-existent? In terms of the special master's monitoring role, how is he overseeing the capital budget, which at this point is not clearly spelled out? I guess I would also like to understand how you are reporting to court on this budget issue in particularly, because it's one of the issues that was raised in court. We would also want to raise the issue in terms of while we were on oversight, we visited a community now I'm trying to place this community, but it was one of the communities we met young people there that were totally displaced with no support, and they even asked of us to assist in their sporting equipment. I remember as a committee and the team that was there, we managed to get them a soccer kit and a netball kit, but I somewhat forgotten the name of the ward as well as the name of that particular community. But if I get the name, I will come back to the minister on this. But I mean, it's labor tenants who we managed to find there seem to have been left on their own after the settlement of their labor tenant application with no other support. And this is generally the findings that we were seeing during oversight. And this is why I'd like to understand in terms of budget, what is the budget allocation for post-settlement? Thanks, honorable members. We'll hand over to the executive. Honorable Minister.
Thank you very much, Chairperson. The question raised by Honorable Mahlo with regards to interdepartmental coordination on post-settlement issues. Indeed, part of what the Interministerial Committee chaired by Deputy President, land reform is an integrated function. It is indeed true that some of those support measures don't lie in the department, nor even in their budget. For instance, issues of water and sanitation would be in the purview of the Minister of Water Affairs, so as human settlement, arts and culture, as well, some of those would be within the sphere of local government, as Honorable Mahlo would know. But what is important in this coordination is that when a settlement is done, even prior to its settlement, the various departments must be of an understanding that in this locality, in this district, there is a land settlement that will be done, be it through labor tenants or even restitution or any other land reform redistribution issues, so that the various departments and spheres of government prepares themselves for supporting those communities with all the necessary amenities, because it's not in all instances that those could be agricultural or other areas which are within our function, but they are part of the municipalities. So we are working together to address these matters that, Chairperson, you yourself said you've picked up in your oversight visit. The issues of distance, and I think it's important for us to articulate that if you look at the various labor tenants, they are not bigger communities where they are. You'll find in one farm that you have got about 2 families, and on the other, you might have about 5, and so on and so on. What is important is also about engaging the farmer, or rather the landowner concerned, so that such services are shared. Because what we have found is that in some instances, after settlement, you will find that water is cut off from those communities or those families, and therefore they don't have water. But also the issues of the access of other services, such as your electricity and, you know, other important services, have become one of the challenge on a situation where the community is smaller to be able to be linked on the grid. So these are some issues that we are deliberating upon with other government departments to say, how do we ensure that services that should be, you know, received by all community members are actually affordable and accorded to these communities? Issues of burial sites. You'd find that a lot of municipalities and districts have not actually provided for the burial site of members that are living in farms. So time and again, when there are such burials, there will be tension. I'm raising all of this, Chairperson, just to highlight that the coordination that we are doing within the IMC seeks to address these very matters that you are raising, where people are finding themselves located in far-flung areas with no basic services close by. On the issues of monitoring by the special master, particularly monitoring his budget, I may not speak for him, Chairperson, but that's part of the function where in reviewing our budget, the special master needs to satisfy himself that this budget for labor tenants, specifically within the whole budget of the Department of Tenure, is adequate to actually address the issues of labor tenants. When we go to court, for instance, as part of our court reporting, we have indicated, what is on our MTF allocation for tenure reform, which also include labor tenants. And within that, in the itemized budget, you can delineate how much of this is for labor tenants and how much of the other is for other related tenure security. And I must commit, therefore, Chairperson, that in your first meeting, when you invite us, we will have to show exactly to you what are the figures of the amounts that are there for settling of labor tenants, as you indeed correctly requested, so that for the committee, it will be clear that for this budget in the MTF, how much capital amount is earmarked for a settlement of the labor tenants claim. Thank you very much, Chairperson.
Thank you to the Honorable Minister, Mahmoud Diza. I was actually struggling to recall the name of the community we visited. It was actually Mpatiswa Ingonyama CPA, which we visited and found to be right on the outskirts boundaries in a farming community, which was located up in the mountains without any access to any services. Obviously, it's good to raise it at this point so that the Honorable Minister can take note of it and find time to visit them and come to their plight. Honorable members, that concludes the business of the committee in terms of what we had invited the Honorable Minister on to brief us and present to the committee on both the issues related to Ingonyama Trust Board as well as the special master. We will now move on to the third item on our agenda, that being the oversight visit of the Portfolio Committee to Kirkwood in the Sundays River Valley, where we were able to engage with stakeholders there and the Sundays River Valley citrus growers, the trade unions, as well as Sanko, in regards to the challenges that they were facing in the area. But let us thank the Honorable Minister and the Executive, the Deputy Ministers, and the DG, Tate Ramasodi, and the officials of the department who participated and assisted us in navigating through this morning session. And thank all those that were able to join us and who were listening in the deliberations of the committee. If you want to be excused at this juncture, you may be excused. Honorable members, I now invite our content advisors and secretariat to flight the presentation in terms of our own oversight report.
I thought to give us lunch.
Hey, Mpatisa, in these virtual meetings, we may desire to offer you lunch, but so basically small. But hopefully next time we will be back in full sitting committee meetings, and particularly on a meeting of this nature when it's our last meeting of the year and we are closing. We should have had a luncheon to close our session. But these things will be noted, Honorable Minister, and we'll hope in the next sessions as we dare look to rebuilding our parliament and getting back to ordinary work of parliament. With that said, let us look into the report, honorable members. I had requested that it be circulated so that we can just go through page by page and identify the issues if they've been covered correctly. But we'll have more emphasis on recommendations that we are coming out with. So page 1. It is a report of the Portfolio Committee on our oversight visit to the Sunday's River Valley. Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Page 11. Page 12. Page 13. Page 14. Honorable members, these are the recommendations of the committee on our oversight report to the Sundays River Valley. In view of the observations and the key conclusions of these recommendations, the committee recommends the following. The presidency should set up an interministerial task team or a committee to delve into the state of affairs at the Sundays River Valley with a view to conduct its own investigations and inquires as well as developing inquiries, as well as developing interventions plans, short, medium, and long term, to resolve the challenges confronting farming communities in the Sundays River Valley, both farmers, farm workers, and community members. The IMTT, given due consideration of all the recommendations of this report, should, through the presidency, report about its plans and interventions at Sundays River Valley to Parliament within 6 months after adoption of this report by the National Assembly. The Minister of Agriculture, Land Reform and Rural Development should, 7.2, submit a comprehensive list of farms that have been leased out to farmers in the Sundays River Valley, indicating the cost of the acquisition, the number of the beneficiaries, the number of years it has been leased for, whether the lease agreement has been renewed, if not, why, and the current status of the farm. 7.3, reviewing of all share equity schemes, strategic partnerships, joint ventures, or any other forms of empowerment schemes or private sector collaborations in the Sundays River Valley, in order to, amongst others, determine if shareholder agreements are transformative and empowering tools for land reform beneficiaries. The review should also consider assessing the financial status of the enterprises since the inception, profit and loss sharing, and declaration of dividends. Further assess the socio-economic impact of these schemes on the lives of land reform beneficiaries, looking at all aspects of the relations of production, power, and prosperity. 7.4, given that South Africa is the second largest exporter of fresh citrus fruits in the world, the minister should consider convening a bilateral with the Sundays River Valley Growers Association in order to address the concerns specifically for the Sundays River Valley with regard to infrastructure damage and financial loss that resulted from the strike as a result, or as well as the mechanism to strengthen market access and how the citrus industry in the SRV can contribute in the fight against unemployment in the Eastern Cape and South Africa broadly, and playing a key role in the economic recovery of South Africa. The Minister of Employment and Labour should, 7.5, ensure that DEL, that being the Department of Employment and Labour, in collaboration with the Department of Agricultural and Reform and Rural Development as a rural development coordinator, and the Sundays River Valley Growers Association develop a database of unemployed people, especially youth, in the Sundays River Valley looking for employment. The Sundays River Valley Growers Association should use the database to source labor, both permanent and seasonal. 7.6 on page 15, using its inspection reports, put together a report that demonstrates the total number of people employed in the SRV, their nationality and place of residence, and the nature of employment in order to determine the veracity of the allegations relating to 95% of farm workers being undocumented foreign nationals. 7.7, ensure that DEL conduct regular follow-up inspection on farms in the SRV to monitor and assess compliance with legislation as well as unfair labor practices that farm workers complained about. Some of the key issues are BCOE, sectoral determination, working hours, OHSA, UIF, and most importantly, employment equity. 7.8, support the establishment of workplace forums as platform for engagement between workers and employees. Similarly, foster environment where membership to trade unions is not hampered by employers or farmers. 7.9, DEL should facilitate engagements between trade unions in the operating in the SRV and SANCO in order to clearly delineate, delegate, what is that? Delineate. 7.9, in order to clearly delineate areas of focus in order to minimize confusion as unions and civic organizations operate in different manners. The Minister of Police and Justice, Constitutional and Constitutional Development should, 7.10, ensure that SEPS and DOJ, NCD, working with the Sundays River Growers Association and Workers Committee and the trade unions, develop a program of information campaigns informing residents that damage of public infrastructure and private property as a form of protest is a criminal offense with intention to instill public ownership of public property. 7.11, the Minister of Justice and Constitutional Development in consultation with the CCMA and the Minister of Labour should review list of penalties waged on those employers who employ undocumented foreign nationals. 7.12, criminal charges should be laid against the perpetrators of violence during the strike in order to deter people from possible destruction of property in future. No, don't gallop ahead. The Minister of Home Affairs should 7.13 regularly undertake inspection at workplace to verify if all foreign nationals employed on farms have valid documents and permits to work in South Africa. Where they are undocumented foreign nationals, those workers must be detained in order to follow the procedures relating to undocumented people in South Africa. Further, work with the Department of Justice and Constitutional Development to ensure that employers that have breached the law are apprehended and pay high fines or impose maximum sentences for the crime so that they are not able to repeat the offense. 7.13, with regard to trade unions, the trade unions operating in the citrus industry in the area should provide a list of their membership and the farms that they are operating, as well as initiatives undertaken or to be taken to increase their visibility in the area. Further, the Department of Employment and Labor should do a thorough investigation on the allegations that trade unions are denied access by farmers and submit the report to Parliament. I move along. Page 16. Sunday's River Valley Citrus Growers Association should consider developing a network of traditional councils and community authorities to supply labor for the Sunday's River Valley farmers. Further explore avenues for attracting unemployed youth in the province of the Eastern Cape to provide labor in the agricultural sector, both down and upstream industries. Unless otherwise indicated, responses to the above recommendations should be submitted to the National Assembly by no later than 3 months after the adoption of this report by the National Assembly. Report to be considered. Honorable members, they are the recommendations of the Portfolio Committee on Agriculture, Land Reform and Rural Development on our oversight visit that we had in the Sunday's River Valley. Can we have a mover for the adoption of the report? Any mover for the adoption of the report, honorable members?
Chairperson, I will move.
Dankie Agbare Breed moves for the adoption of the report of our oversight visit to the Sunday's River Valley. Any seconder, honorable members?
Chairperson, may I second this report?
Thank you, Honorable Mahlo. Seconds the adoption of the report of our oversight visit to the Sunday's River Valley. Honorable members, that brings us to the end of our business for the day.
Thank you, Chairperson, and thank you very much.
Thank you, Honorable Member. So, honorable members, it has been a great year, exhausting, tiring, but we are almost there. Almost to our finishing line. I see with the last remaining minute, we are able to squeeze in the last set of minutes, which is very brief. The minutes of the 22nd of November, 2022.
Chair.
Page 1. Ntate Masipa?
Sorry, my hand was up. I realized that you did not.
Your hand was never up, Honorable Ntate Masipa. I've been looking at the hands through and through. Just say that you'd like to raise your hand now and I'll recognize you. You may proceed.
I'm lowering it now, so I'm not raising it. Chair, I just want to say thank you really for the quick response in terms of attending to the matters of Sunday River Valley. I couldn't really go with you guys, but I must just be honest, Chair, that I think in the future, we need to be more responsive when things like what has happened in Sunday's River Valley happened. I think as a committee, we definitely need to be more responsive and quickly attend to these matters. I like the recommendation, but I thought it very important that I'm on record in terms of really, I think we need to be more responsive. When things like this happen, we cannot wait for 6 months later to go and visit. We needed to be on the scene there and then when the riots was happening. Thank you, Chair.
Thank you, Honorable Dr. Masipa. We work within the confines of the processes of Parliament and the budget constraints that Parliament has. So sometimes we are unable to hop onto a plane and go on to doing oversight, particularly because of the processes of Parliament. We also need to identify stakeholders that we are going to engage with when we go on such oversight. So in a state of protests and strikes, you may not be able to engage thoroughly with those stakeholders. So I think the team that was able to go out and meet with the stakeholders has been able to do a exceptionally good oversight, and hence we have been able to table a report before the portfolio committee. Honorable members, we were on the last minutes of the committee, that being the 22nd of November 2022, page 1. Page 2. Page 3. Thank you, honorable members. Can we have a mover for the adoption of the minutes of the 22nd of November 2022?
Chair, I move for the adoption of the minutes of November 2022. Thank you.
Thank you, Honorable Ntate Masipa. Moves for the adoption of the minutes. Can we have a seconder?
Chair, this is Kappa. I second the move to adoption of the minutes of the 27th of November 2022.
Thank you, Honorable Kappa. Seconds the adoption of the minutes of the 22nd of November 2022. Honorable members, any matters arising? Page 1. Page 2. Page 3. Thank you, honorable members. With no matters arising, that
Chair?
concludes. Yes.
On the issue of
Honorable Dade Masipa.
Chair, on the issue of the commodity groups, and I think we have been, engaging on this matter, which is item number 4.2. Yeah, I have seen that the DG had the conversation with the CEOs of the industry. And it is my view that as a committee, we can basically kind of looking at adopting that approach of maybe, having a public an engagement, a public hearing, or whatever you want to call it, but really to hear the industry forum out as a collective. And when we plan this thing, I thought, let me just put this point, and maybe, the secretariat, when they plan, they can really consider that option as well. Thank you, Chair.
Thank you, Honorable Ntate Masipa. The committee, when we plan and when we do put our program for 2023, we will take that into consideration. With that said, honorable members, the minutes of the 22nd of November 2022 have been duly adopted. May remind you, honorable members, we have plenary at 2 o'clock. So please log in on time at 1:30 for those that will be joining virtually, and those that will be in the house, look forward to seeing you in the house. Have a great week ahead, and do send our love and greetings to your families and your loved ones. I will look forward to a much needed rest. And I do hope all of you will take this holiday season to truly rest, because it has been a roller coaster year trying to navigate through these meetings and ensuring that we are also keeping the upkeep of our hybrid meetings in the Good Hope Chamber. So do have your rest. And most importantly, please be safe on the roads. A season has a tendency of getting a lot of road accidents, and we lose many of our loved ones on the roads. So please ensure that you make stops timelessly as you are embarking on long distance drives. Like myself, I'll be heading back to the countryside, and with the family, we do drive back to the countryside and enjoy the beauty of our garden route. So I will ask all of you to make stops and rest when you need to rest, and don't be exhausted on the roads. Stay well. We'll see you in the new year. The meeting stands adjourned. Thank you.
Thank you.
Bye.
Thank you, Chair. The minister can join me for a coffee later.
Bye-bye, colleagues.
Thank you, Chair, and Merry Christmas and Happy New Year to those whom we are not going to meet until next year.
We'll catch you then. We'll send the messages then.
Bye, colleagues.
Bye-bye.